Good afternoon. We're here with the Commission on Sentencing for the policy hearing or meeting, really. We're going to discuss, when I say we, the executive director and the senior deputy director, discuss several areas to include the proposed eighth edition for the sentencing guideline and some of the other proposed action items that we'll be working on. And so before that, though, we had public hearings this morning, and one of the individuals signed to testify had a delay, Mr. Jones, Reuben Jones. So what we're going to do is we're going to open up today's meeting. Oh, and I want to welcome the other commission members that we have present. We have Judge Ed Marsico and Representative Tuski present, and then I don't know. Oh, and right. Thank you. And I introduced myself, but I forgot to introduce her. And then do we have anybody via Zoom? So we have attorney Doug Marsico and Representative Bonner. Welcome, join us as well. And then what I'm going to do is I'm going to turn it over, and I indicated to Mr. Jones, once he introduces himself and indicates on whose behalf he's presenting, then I'll begin the 5 minutes for testimony, and I'll generally give a 30-second warning to wrap up. But with that, Mr. Jones, if you want to introduce yourself, and you may begin with your testimony. And we did receive your written testimony as well, sir.
Thank you, Your Honor. And let me just start by saying thank you for indulging me. You guys have taken the time to allow me to present this testimony. And I commend this honorable commission for your courageous efforts to transform the sentencing process in Pennsylvania. My name is Reuben Jones, and I'm currently the executive director of Frontline Dads, Inc., a 501c3 nonprofit based in Philadelphia. I also serve as a campaign lead for Dignity and Power Now, social justice advocacy organization, and we fight for a lot of criminal justice reforms across the board. So, and I'll read my testimony. I'll be brief, but I'll be more than happy to answer any questions anyone may have once I finish. So again, my name is Reuben Jones. I'm executive director of Frontline Dads. I also serve as the campaign lead for Dignity and Power Now, where we fight to transform the criminal justice system and address the racial disparities where African-American men are disproportionately represented. My role as a social justice advocate, I fought for criminal justice reforms such as bail reform, probation reform, parole reform, ban the box, code relief for incarcerated people, parole eligibility for lifers, inhumane prison and jail conditions, jail closures, and opposing risk assessment and electronic monitoring. Additionally, I served as a social service coordinator for Philadelphia's Both Deterrence Gun Violence Prevention Program, in which record lows were recorded as a result of an almost 50% reduction in gun violence in 2013, which is the lowest total in 50 years. For this effort, I received numerous awards and recognition, most notably a Presidential Service Medal from President Barack Obama back in 2016. I have a long track record as an advocate, and my expertise is unmatched. My integrity is impeccable. Therefore, I want to challenge this board or this body on the proposed revisions to the sentencing guidelines. Although the Pennsylvania Sentencing Commission has stated that the body wants to prioritize the rehabilitative needs of those who have committed low-level offenses, there's a lack of non-carceral recommendation for those who commit serious crimes but might have an undiagnosed mental health and or substance abuse issue. Those individuals need appropriate treatment, not a fast track to being institutionalized. The addition of language for treatment alternative, including medication and assisted treatment in lieu of incarceration, will lead to a reduction in recidivism and boost harm reduction across communities. All reforms to the criminal legal system must take into account the racial impact of any changes to the guidelines. The commission should also take racial disparity seriously and should conduct a racial impact study before implementing any new changes to the sentencing guidelines. Changes to the score, which determines the length of a person's sentence based on their past criminal record, is an improvement compared to the previous proposal that included more severe penalties for those who commit lower level offenses but have more frequent contact with law enforcement. But because of these changes, those who commit more serious crime without a prior record will receive more punitive sentences. This is particularly dangerous for individuals with mental health and or substance abuse disorders. The recommendation to cap probation at 2 years will not only benefit those under supervision, but it will also relieve the burden of lengthy probation sentences on county probation department resources. I think any effort to lessen the financial burden on the state while providing adequate resources to the formerly incarcerated is a good thing. I'm here today to call upon this honorable commission to utilize the same thinking as it relates to people serving state parole. It is my belief that state parole has diminishing returns and should be capped as well. We believe that the sentencing guidelines should be changed so that no one serves an inordinate amount of time on state parole. Therefore, I'm asking this honorable commission to explore ways to provide an off-ramp for state parole. This sunsetting, if you will, of state parole can be addressed by creating a good time provision in the sentencing code. This way, people serving state parole sentence can earn their way off of state supervision by meeting certain stringent criteria. This approach will help save the state money. It will reduce caseloads. It will also reduce caseloads of POs. It will also reduce recidivism by providing an opportunity to have state parole terminated. The criteria can include employment, school or training, no infractional violations, community involvement, and recommendations from respected leaders, such as those in attendance today. We believe this approach will provide an incentive for parolees to comply with prescriptive programs and supervision expectations. We have to look at the sentencing guidelines as more than just punitive, but it can also be transformative by creating the opportunity for people to thrive and be welcomed back into the mainstream rather than continue marginalization where they are hampered by the stigma of incarceration and limited by the invisible shackles of supervision. The data shows that after 3 years, parole supervision has diminishing returns. Approximately 70% of recidivism occurs within the first 3 years of release. Most people don't need to be supervised after 3 years, even when they have committed violent crime. Therefore, the sentencing guidelines should be changed to reflect the ever-growing needs of people on state supervision. In conclusion, I'm asking this honorable commission to consider exploring ways in which the sentencing guidelines can be included to create a sunset provision so that men and women can earn their way off parole, state parole, by doing the right thing, which will subsequently save the state money while making the community safer and less traumatized. This sunset provision would essentially serve as a good time provision for those serving state parole. It works the same way good time works for a state prisoner or someone who's actually incarcerated, except that the person is already home and serving a state parole supervision sentence rather than a state prison sentence. For those who qualify, the parole sentence will be terminated once the specific criteria has been met. It is my hope that this honorable commission will consider this proposal to cap state parole sentences and provide a sunset provision for those serving state parole sentences so they may earn their way off of state supervision. It is my hope that you will undertake a process to implement it along with the other proposed changes to the sentencing guidelines. And with that, I want to thank you for allowing me the time to speak and share my testimony. And if we have time, I'll be more than happy to entertain a question.
Thank you so very much for your testimony. We'll turn it over to the executive director.
Sure. First, I want to thank you as well for your comments. I wanted to mention a couple things the commission has done that I think hopefully address issues you've raised, although we can't do everything. On the issue of racial impact for the sentencing guideline proposal, we did do a resource utilization, and as part of that, we're trying to also look at the racial impact as well. It's incomplete, but we'll continue to work on that and try to make that available when we make available the guidelines, the final guidelines. One of the things we really focused on as part of the review process was the commission established what was called an academic review panel. And the focus of that group in reviewing the guidelines was to really focus on race and ethnicity and the impact in sentencing. And so a number of the changes that are proposed in the guidelines, both in terms of targeting the sentence recommendations and especially reducing the prior record score, was intended to reduce what we saw as disparity in sentencing based on race. So thank you for that comment. We hope we're moving in the right direction, but we're certainly trying to address that issue. Regarding parole, the commission does have sort of an opportunity to promote best practices and trying to address some of the issues you raised. But one of the structural issues in Pennsylvania is just the nature of how sentences are imposed. We have, the min-max rule that basically provides that, the maximum term is at least, double the min. And because of that, if someone has a substantial minimum term of confinement, if they're released at their minimum, they have a substantial maximum to serve. And at least at this point, there's not a mechanism aside from a commutation or pardon that would change that structure. So part of that is a legislative issue if there was going to change in that min-max rule. But what we have done, what the commission did do, is adopt parole guidelines, which are now in use by the parole board. And the real focus on that was also to create greater certainty about parole decisions, a more objective and transparent process, but also to try to be neutral racially. And in fact, the risk assessment, there was a lot of efforts taken to try to address racial impact in that. So I think the commission is certainly trying to do those issues, but I appreciate you raising them, and we'll continue to work on those. And thanks again for your time.
Thank you.
May I
And
respond briefly?
you may.
Just briefly.
That's sure.
So, no, I actually start out by commending this commission for, I think Pennsylvania's about to take a huge step forward in regards to, so thank you for just sharing that and agreeing, and I agree. We do believe that it's going to take some legislative approach, but we want to have the support of this commission because the way state sentences are structured in PA, your parole is actually a part of that sentence, right? So when you say if you're doing a 10 to 20, and you serve 10 years, you release the parole. So you have 10 years of parole to do. So that's the sentence. But what we're asking is creating a provision that allows a person to earn their way off of that sentence. So after 3 years, perhaps a review or send it back to the judge for resentence, whatever that mechanism could be, as long as they meet the criteria. Obviously, it wouldn't be automatic and it wouldn't be a low bar, but there would be an opportunity folks to come back after we meet the deadline in which the data demonstrates that they're diminishing returns at that point. So that's why we're suggesting 3 years so that at least the person can be reviewed, and it will, above all else, it will help lessen the caseload of the supervisor and parole agents. If he has 300 or 400 people on his caseload, and half of them could be released because they are actually doing well, which is what we want to see, then I think it helps stay across the board. So I just want to make that point.
Thank you very much. And then Representative Krajewski, the vice chair.
Thank you, Chair. Thank you, Mr. Jones. Good to see you again. And thank you for all the work that you do for our folks in Philadelphia. Given, so Mr. Jones and I have worked together on a lot of different issues back home in Philly. And one of the things that's come up in our review of the guidelines and a lot of these hearings has been the role of costs and fees as it pertains to sentencing and incarceration. And I know that's an area where you've done a lot of work in. So I'd be curious if you could share a bit more about your perspective on that and how the commission should approach costs, fees, and the financial considerations when it comes to sentencing.
Yeah, it'll probably take a much larger discussion, but the issue with court costs and fees is oftentimes, unfortunately, when people have a prison record, they're not, there's the exception, but for the most part, we're relegated to low wage jobs, right? So it's barely enough to either make rent in a place that you're sharing with the relative, phone bill, and transportation. So sometimes those fees are actually a hardship. And if not paying the fee is going to either cause a violation or extend the supervision, then we begin to continue to the cycle of incarceration, which we're trying to end. So I do think creating some feasible way to either, and I know this may be a bad word, but some way to excuse some of those fees. We know that the people have to be held accountable. We know that there's some financial redress that has to be made. We know that there's a supervision fee attached to parole supervision. And that's why we're proposing, if we could break that 3-year window, now the person in that 4th or 5th year, 8th year, 9th year, they're not continuing to pay a supervision fee for someone who doesn't necessarily need to be supervised at that point. And we get it, public safety is at the heart of all these conversations. So we do want to maintain some mechanism to feel safe and trust that the person that is being sunsetted off of parole will still be accountable to the community. So we're not excusing the level of accountability, but that financial hardship, supervision and court costs, and those things can only add to the continued cycle of perhaps potentially recidivism, but at least financial challenge.
Thank you very much. Thank you for your
Thank-
testimony today.
Thank you.
And then I'm going to turn everything over to the executive director to begin our discussions.
Well, good afternoon. I see Judge McDermott has joined us. Good afternoon. What we're going to try to do is systematic review of the comments we received. And as you recall, we had 6 public hearings, the most recent this morning, but we also received other comments in writing, both just email exchanges and documents, and those have been provided to all of you. I'm going to ask Ryan to sort of manage the display, and what we're going to do is start with what I believe is a handout you have, which is the text of the sentencing guidelines, the proposed guidelines, and it's there's a markup with it. We did this last year when we were going through comments, and it seemed to work pretty well. But we've marked up or inserted a bunch of comments for your consideration, and then we're certainly open to other suggestions that you want to take into account. Ryan and I both attended, I believe, all of the hearings, and so I've tried to capture things in this document, but I'm sure I've missed stuff, and so Ryan will be here to be the truth teller or to fill the gaps, and again, if there's other issues that you want to raise, please, this is the opportunity. So we're going to move to page 3 of this document, the first insert. And this is the definition section, but the insert deals with a new term that we'd like the commission to consider. It's the term administrative probation. And the reason for requesting or suggesting this is that in several of the public hearings, and especially I'd say in rural counties, even before the public hearings, we heard support for level A, which is restorative sanctions, fines, community service, guilt without further penalty, but especially for fines and community service or restitution as sort of a standalone sanction. The way we were presenting this was that many of the offenses that we have targeted for OGS 2, which would be level A, are offenses that in some counties are handled by magisterial district judges or through municipal court. And when they're in common pleas court, one option to consider is to treat them pretty much like you treat them at those lower courts, at the minor courts, with standalone sanctions instead of long periods of supervision. But there are some complications in things like ordering community service without any kind of probation order. So the idea was to try to put into words in the guidelines what is in practice in a number of counties as non-reporting probation or other things like that, where you'd have a period, you'd have a mechanism of probation where courts have some control over the case, but the whole purpose of the probation is just to provide support and monitoring to achieve whatever the condition is, whether it's a fine or community service or something like that. So we thought it would be helpful to create this term of administrative probation and use it for that purpose, that the intent is not to have community supervision of the case, just to monitor those kind of conditions that are imposed and remove the person. So this is in response to what we've heard from a number of counties. And what we'd see this as sort of fitting into is that level A of the guidelines, restorative sanctions, where it would be not community supervision, but just trying to monitor and promote the successful completion of those conditions. So that definition is embedded in here, and then you'll see later in the document, we build it into the restorative sanctions area of the guideline. No questions on that. We'll just keep going. The next page, page 4, we have the definition of crime-free for use for lapsing. And as you can probably expect, we heard comments on sort of the two extremes of this. Some of the commentators suggested that crime-free should only, the starting point of the clock for time-free should be after completion of the sentence. So if you got a 5 to 10, we start the clock after 10 years. And that's when we start considering the crime-free period. There's other people that wanted to start the clock at the time of sentencing, even if someone received a 5 to 10 year sentence. And what the policy is that we have in place is effectively when the person is placed in the community, when they're sort of at risk, is when we'd start the clock. So the way that operates under what's proposed is if someone's placed on probation, that clock begins at sentencing. If someone receives a 5 to 10 year sentence, that clock starts when the person is released on parole the first time. And then any kind of subsequent new offense would stop the clock or restart the clock because of that offense. There were some suggestions as well that in addition to a new offense being the mechanism to interrupt crime-free behavior, some suggested that a revocation of parole or probation, particularly parole, because of a technical violation, should also stop the crime-free clock and restart it upon release. So those are the comments we received. I guess staff is generally supportive of sticking with what we have, which is we start the crime-free period when a person is released to the community, and that could either be on probation or on parole.
I think given, like you mentioned, the two extremes, it seems like that's probably the best way to split the baby, to just keep it as it is. I'll just also voice concerns about the technical violation as part of ending someone's crime-free period, just because the range of technical violations is so broad. And I think there are a lot of technical violations that just feel inappropriate as a reason for terminating someone's period of time. So I think given that, I would be in support of just not adding that to.
Right. And under the current proposal, that does not interrupt a crime-free period.
Okay.
All right. Continuing on page 5, we have sort of some technical issues. As we get to talking about sentencing guideline forms or the SGS web application as the mechanism for preparing guidelines and reporting sentences to the commission, we're well aware that we're in the process of trying to rebuild that application, the next gen application. We don't know what that thing's going to be called. We don't know what it's going to look like. It's sort of in the process of becoming. And so we wanted to make sure that in writing the guidelines, we were a bit more generic in how we referred to that application. So the idea is to refer to it as the sentencing guidelines application instead of SGS web or something else. One of the other things, and we can talk more about this, I guess, tomorrow during the quarterly meeting, but I know I talked to some of you previously about just the mechanism for putting these guidelines in place, and we're building a new application for that purpose. But we also appreciate that just like in building guidelines, building an application takes a lot of time, and we want to make sure that it's ready for prime time when we deploy it. And so there is some I think consideration, and we've discussed some efforts to basically build into the current application sort of an instance of the new guidelines, so that during 2024, we could effectively use the current SGS web to operate the new guidelines while we're rolling out the new application. And that would sort of separate out people learning about new guidelines and how they operate, how it's supposed to do, from learning a new application, which would be this next generation application. So I just sort of mentioned that in saying that when we talk about the application, we're talking sort of generically about whatever means the commission has of preparing guidelines and getting information fitted to. Next page, page 6. The first listing there is REVOC, repeat violent offender category. So this is a term that the commission created and has been using under previous guidelines to refer to repeat violent offender, sort of the equivalent of 3 strikes under the guidelines. As we discussed during this morning's hearing and in previous hearings, REVOC presently is based on a current crime of violence offense and 2 prior crimes of violence. So the prior record score has 2 prior crimes of violence. But what should be clear is under the current guidelines, in a single incident, someone could have 2 crimes of violence, because under the current policy, consecutive sentences, all of the offenses are under consideration, and consecutive sentences count as both offenses would count in the prior record score calculation. So if someone was convicted of a single incident, a prior conviction had a single incident with 2 crimes of violence, and the court imposed a confinement sentence on one and a probation consecutive on the other, both of those offenses would count in the prior record score and could get the person into REVOC. So under the current policy, we have that in place. Because the new prior record score category 4, which is sort of a combination of RFEL and REVOC, has a different set of rules in place, just takes a case where there are 2 crimes of violence in the person's criminal history, and it doesn't matter what the current conviction offense is. It's probably not helpful to be labeling it as prior record score 4 parentheses REVOC. So what we're recommending is we just eliminate the use of the term REVOC, because it really associates with prior guidelines and a different approach to prior record score than the proposed guidelines. So we suggest that we just remove reference or delete that definition, because it's not functional anymore in our guidelines. Right below that is restorative sanctions. And what we'd ask here is that we perhaps broaden the definition and maybe change the definition. As I said, one thing that we would add to the definition of restorative sanctions would be administrative parole. But another issue that was raised this morning during the public hearing was administrative probation. Sorry, it all runs together. The parole I'll get to later, I guess. But so administrative probation. But the one thing that was discussed this morning during the public hearing were the economic sanctions that fall under restorative sanctions. And certainly restitution and fines are in there. And we always include community service in tandem with the fines because of the separate guidelines we have. The question is, do we include costs and fees? And the commission has traditionally included those. There's provisions in the sentencing code about costs, but as was, I think, appropriately mentioned this morning, costs are really reimbursements and fees are just a different type of cost. And so I think it's an appropriate reference point within the guidelines. And I think it's, there's probably a valid argument to say, well, they're not exactly restorative sanctions because they're really reimbursements, but there's something. And the heading that we have, the umbrella we have for restorative sanctions are basically non-confinement, non-supervision options or alternatives for courts to consider. So it's really up to the commission to decide, do we keep costs and fees in the guidelines as sort of a reference point and continue to refer to them as restorative sanctions, or do we take them out? And it doesn't really impact the guidelines much. We're just saying, here's statutory stuff for you to consider when sentencing. So I'll defer to the members of the commission on whether we keep that in or take it out. First question for you.
Open it for thought. Yes, Sunday.
A question I have is, in having dialogue here with my colleagues that are on the bench, I'm curious what the practical impact of that would be that you think.
I don't think anything. I think the only concern I have is there are mandatory court cost fines. And as a judge, I don't have any discretion in imposing those. So that's the only response I have.
Yeah, I'd separate the fines, because we certainly fines are a statutory provision, a sentencing alternative, and also we have a mandate to have guidelines for fines and community service. But costs and fees are, we're just like, the reason we put it in there is to recognize that that's a responsibility, but not that we have any recommendations about them. It's like a reminder almost, or we build it in, but I'm not sure that it has, much substance in terms of the guidelines. So it's your call.
I'd take it out based on what the ACLU guy was saying
Okay.
this morning too.
Take it out. Okay, so we'll remove it from the text of the guidelines, and we'll also remove it from the definition of restorative sanctions, and courts can do that on their own and like a
Note that
side issue.
Note that I took that up for the ACLU.
I think we have that on the record right now. So thank you, Judge.
Well, if I may just real quickly, I apologize. Question I have about that is, will there be anything taken from the fact that it was there before and it has been removed?
We can, in addition to the text of the guidelines, we will then write commentary when we publish the guidelines, and we can put in a statement that, is excluded because of this issue, but it's still a requirement for the court to consider it.
Thank you, Mark.
Does that work?
Yep.
Excellent. So Ryan reminded me, we should probably get some kind of direction from the commission about administrative probation. Are you fine with including that as a restorative sanction, that concept of administrative probation?
I actually had a specific question about
Sure.
that, just more so understanding. So administrative probation specifically is about supervision, like
Not-
probation with supervision.
I'd say more monitoring. Like
Monitoring,
when
okay.
supervision, it seems to me, is more about curfew and drug testing and a lot of other, general conditions under section 9763 that relate to conditions of probation. But this is more, here's the issue that came up. We have guidelines for community service, and we also, it's part of it's listed as a restorative sanction. There are at least two places in statute where they reference courts imposing community service, but but community service is not listed as a sentencing alternative. Like when you go to section 9721, there's community service is not listed as a sentencing option. So I think the interpretation of that is it can be imposed as a condition of probation. Well, what if you're not placing someone on probation? How do you impose community service as a standalone option? Well, the remedy may be impose probation, but no conditions other than community service. And then the purpose of the probation department is to monitor progress and try to promote completion of the order and report it back to the court or do any other kind of issues like that. The same could be said for fines and restitution, just facilitating it. But, when we start getting into probation and duration of probation, we get into all those other issues that have been raised as concerns. And so we want to make sure this is like a stripped down version. Some counties, they call it non-reporting probation, but you might have someone report if they're supposed to be paying restitution or something. So that's probably not the right term, but administrative, I think, connotes that it's very limited, sort of stripped down, and it's just for the purpose of implementing an order.
Okay.
So I think just on that, it might be worth fleshing some of that out a bit more in the definition of administrative probation to just include some of those non-confinement options. Just because on first glance, when I'm reading that definition, my brain just goes to, okay, it's like supervision. And I know there's a suggested change there, and just maybe it's just worth fleshing out a little bit more that may include community service or non-confinement options.
So here's the definition we have right now. So I'm open to it. And this is the one on page 3.
Yep.
An order of probation with supervision and conditions limited to that necessary to monitor and promote successful completion of restorative sanctions and or other court ordered obligations.
Right. Yeah. And so I guess maybe just my confusion is if I read supervision, like that, to me, that just goes to kind of typical probation supervision, but you're saying actually it's a more expansive definition where supervision could mean, you know, we're just making sure you're completing your community service or
Right.
making sure you're paying your fines.
Yeah, the focus there is it's about the limit on supervision and conditions so that the next part is to monitor and promote successful completion. So I think the focus of the probation is monitoring and promoting successful completion.
Mark, what if you would put in limited and add the word only to that necessary
Okay.
to monitor and promote successful completion of restorative sanctions? That way it's sort of limits it. The other issue I think where this comes up, I don't know if my colleagues do it, but yes, sometimes, yeah, all I want's the fine paid. All I want's restitution made. I don't want the person super.
And that's fine.
Or I want a drug and alcohol foul
Right.
and just want them to complete that, you know, so that I think would fit.
Right. And that's one of those things where, you know, as presently written, we have those as like standalone options, but the feedback we received in certain counties was that there needs to be like a mechanism to order that. And you can order a lot of things and then you use contempt as the mechanism for enforcing it. But at least in some counties, the practice would be this like administrative probation. But thank you. Any other comments on that? Judge? I mean, Rep?
Oh yeah, just going back to the restorative sanctions sections.
Yeah.
I just kind of recall if we had made a decision on section B and the inclusion of language about the court considering the defendant's ability to pay. Did we?
Yeah, I'll be getting to that and you'll see it's coming up in the next couple of pages. So for restitution and fines, hopefully we incorporated the comments that the ACLU provided, but if not, I'm sure you'll let me know. So any other comments? Okay. So, so we'll remove, remove costs and fees from the definition of restorative sanctions, and we will include administrative probation, and we'll try to finesse the definition of administrative probation. Moving down to SGS Web, that's we talked about that before. Moving on to the next page, page 7.
Quick question. I apologize. I don't mean to overcomplicate things, but
Sure.
going back to restorative sanction,
Mm-hmm.
as I'm thinking about this, are there any mandatory fees that go into a restitution funds?
I think I know we did work on the victim compensation, and I'm trying to think if it's called a fee, but it's really reviewed. It's viewed almost like restitution.
Mm-hmm.
There's a mandatory requirement, so I'd have to look at that. But the point is, we don't want to exclude that, right?
That's
we want
correct,
to make sure
yes.
that's okay. We'll make a note of that and try to make sure, you know, whatever definition we're coming up with captures that. So
I appreciate that. Thank you.
victim compensation. Yeah, I sort of recall. I remember we worked on a project trying to look at restitution, collections, and recidivism, and victim compensation was a big aspect. And I think it's considered restitution, but we'll check. Thank you. So back to page 7. The first highlighted issue is sentencing alternatives. And I think this gets to the issue of administrative probation and also the cost stuff. So I think we've discussed that. As we move into the section that deals with fines, which is under B, this is where we would want to put in a reference to section 9726C and D, which deals with requirement that the court consider the defendant's ability to pay. So that was the issue raised by the ACLU. And then moving down to C, which is restitution. This is where there are the two methods of ordering restitution, a direct order or an order as a condition of probation. So we have included that. And for purposes of level A, where restitution is imposed as a condition of probation, we would reference then administrative probation rather than typical or whatever you call the other probation. And then we've discussed that D will be removed. That's the cost section. And E will be removed, I believe, the next page, which is the fee section. So we will remove the two of those, but we'll check on victim compensation just to make sure that isn't caught up in that. And so on page 8, this would be where we insert a reference to administrative probation as a restorative sanction. So we just sort of close the loop on that. And then we have the other sentencing alternatives listed. So unless there's any questions on that, we'll keep moving through this. You get a free ride for about 4 or 5 pages. So congratulations. We're on page 14 now. So at page 14, we get into the sort of sentencing standards, sentencing guideline standards. And one of the issues that the commission has had in place, I guess forever, as long as we've had guidelines, are that guidelines are prospective. We always take into account the start of a new edition of guidelines for offenses committed on or after that date. So that's pretty straightforward, no problem. But these guidelines are going to be fundamentally different than previous guidelines. So think about the circumstance where early next year, someone has committed some offenses in December and has committed some offenses in January and is in the court in March for guilty plea and sentencing. And so you have these two very different sets of guidelines in play. And while it is possible that you can, prepare the guidelines for the one under the old system and the guidelines for the new ones under the new system, we're trying to simplify and streamline the process, and that adds some complication. And eventually that'll go away, but certainly, in 2024 is going to be a transition year. And so what language that we've had in the guidelines in the past where it's unclear about specific dates of offenses. Think about sex offending over a period of time. And you don't know the anchor dates particularly well, but the most recent date. And what we say is when it's unclear, then just use the most recent date and use the guidelines for everything under that most recent date. So that's not exactly prospective, but it's a way of accommodating a confusing situation and set rules. So what we wanted to bring to the commission is there a benefit worth considering that because these new guidelines are so different, when we have circumstances where at least one of the offenses was committed on or after January 1st of 2024, all of the offenses within that judicial proceeding are prepared under the current guidelines. Now, the caveat or a qualifier that I'll add to this is these are advisory guidelines. So if these were presumptive guidelines, we could not do that. We could not, retroactively apply new guidelines to old cases. But these are advisory guidelines. So I think there's some latitude in consolidating cases based on the most recent offense. But this is really it's a practicality issue. And if you'd prefer that we just stick to the regular rules, we'll stick to the regular rules. But in terms of automating this and in terms of, ease of use, having the current guidelines or the new guidelines apply to all offenses as long as one of the offenses is under the new guidelines would be easy.
Does that open up the discussion?
It sure does.
Does anybody?
Yep.
Anybody want to make comment on that?
Mark, is there any historical precedent to this specific situation?
Just the way we handle sex offenses or any offense where older offenses, the dates are unclear, that we wouldn't know which edition applied. So we just revert to the current guidelines. That's the only circumstance, sort of a carve out that we have in the guideline.
I mean, I think that makes sense when it's unclear that you use the new ones. I think the bigger question is, if I have somebody getting sentenced a year from now.
Yep.
They have some offenses that were
Yeah.
2023, some that are 2024. I mean, I don't care necessarily either way. And it is problematic because you say as you go away with time, it goes away, and you're right. But I had somebody like 6 months ago that was on had a warrant for 25 years. And we were trying to find the guidelines from, 1999.
Yeah. And part of this is it's in a combination. So look, we could, separate from this approach, a different approach could be that, at some point we just do not provide an application for older guidelines. Because think of what we're doing. We're rebuilding guidelines. So we're going to be running an entirely new application for guidelines. And we have our current very old guideline application that we're using. And at some point, it's going to break down. And so it's not exclusively about which guidelines to use. It would be easy to just pick the old guidelines. It's how do you automate it? How do you collect the information? How do you calculate it? And so maybe a different approach is just for us to say, at some point certain, maybe 2 years out or whatever, the commission just won't support an application for those old guidelines, and it'll be the old paper form, which is basically what we do when someone calls us and says, "Hey, I have an offense from 1989," and we provide the guidelines, but it's old school like paper, and we can do that for this. It's just we don't want to be 3 years out trying to stand up or hold up an old application so that every once in a while when an offense is an old offense, you can calculate it through SGS1.
If I can jump in, because I was one of the judges that had to make a lot of phone calls to get old guideline forms when the juvenile lifers were resentenced, and we had a significant number of those. And I didn't find it onerous. I mean, yes, you're going to have to stop the web application at a certain point, but you're just going to have the forms. The concern I have is if there's a significant deviation from the current forms and from the guidelines, not the forms that were in effect at the date of the offense, and I'm resentencing someone, I can see where there might be an argument that someone gets a benefit or someone gets a detriment. So I'm more comfortable using the date in which the offense committed and the appropriate guidelines. And it's a little harder for us. You pull out your old book or you call the commission. Where the date is uncertain, we really shouldn't have any of those dates except for the sex cases, where there's a range where a child or an adult now says, well, it happened from this date to this date. And every now and then you might have a range between two different guidelines.
Right. Exactly.
But I guess to me, yes, we have to accept the fact that the technology is going to go away, but I would just as soon stick with the guidelines that were applicable to the date of the offense, because then I don't have someone else filing a petition saying, hey, X got resentenced under the current guidelines. I want to be resentenced under those.
Right. No, great point. And so we can do that. We may come back with some language or just an understanding of the commission that, at some point we decommission old sets and we go paper, but that's okay. That's fine. Okay, great.
You just don't need the carbon ones like we used to do.
We got into carbon less, as I recall. So that
Yes,
was
you
that
did.
was a huge improvement. So okay, great. Thank you very much for that. So moving down the page, bottom page 14. We talked about this a little bit this morning, and this has been raised in a couple of public hearings about our general recommendations about things like concurrent or consecutive sentencing. And what the commission talked about before, but we weren't crystal clear in how staff drafted this, was sort of a distinction between the guidelines that deal with the offense-specific recommendations, which are very detailed, and we're talking about all that kind of stuff, and more general policy guidelines regarding concurrent consecutive and aggregate sentences and consideration of, what's the maximum period of probation or alternative programs for aggregate terms of confinement. And so what we're trying to do in just, I guess, clarifying the text is to separate those out and to talk about offense-specific guidelines, which are OGS, prior record score, that kind of stuff, and judicial proceeding benchmarks. Just some different term that sort of talks about these general policy statements that we ask the court to consider during the sentencing hearing, but they don't have the same force as the guidelines. We're not determining conformity to the guidelines. And that way the commission can make a statement about concurrent consecutive, but it's not an issue for appeal. It's more just to sort of provide a framework or a starting point for courts to think about how to package multiple sentences together. So I think that's what we talked about before. And I think as we got to writing it, it was just not as clear. So I think the language we tended to use in the judicial proceeding stuff is we encourage the court to consider. Instead of on the guidelines, we're recommending something. And so that's what this tries to get at. In the sort of intro to the guidelines, we sort of separate out the two. Here's the offense-specific recommendations. Here's the judicial proceeding benchmarks. So we can pick any word you want. We just wanted to find a word that wasn't recommendation. And we wanted to use the term encourage in that section about judicial proceeding and use recommendation when we're talking about offense-specific guidelines. So I'm open to any comments or suggestions about that. Picking a word other than benchmark, but we were just trying to find something that was different. We could say a policy. We could say, yes, any number of things, but and I guess we don't have to decide at this moment, but that's what this issue deals with. So you'll see that under 2I, it focuses on the offense-specific recommendations, and II focus on the judicial proceeding benchmark.
And if I could just make a suggestion, I think, does anybody disagree that we should delineate those two? I think that's pretty clear. And then linguistically, I think we should come up with something besides benchmarks, because that
Okay.
sounds very, I don't know, that doesn't sound, it's a suggestion or a
Policies?
consideration. Well, what I was going to say is, why don't we roll that around
Okay,
and tomorrow morning, if
Okay.
anybody, and if nobody has anything, then we'll go with it.
okay,
I'll come up with that.
that's great. I'll start the clock. It's 2:00. So by
Well,
9 a.m. No, okay, thank
That
you.
works.
Okay, so turning to page 15. Most of the stuff at the top of the page just deals with SGS Web, so we've talked about that already. When we get down to the bottom of the page in the offense gravity score section, this is an error because we created a couple more categories of murder, that G1 and G2 for murder 3. So this just sort of corrects the text. So there are 8 OGS categories limited to assignments for murder 3. So that would be the replacement text there. And now we have several pages of nothing. Page 19. is the next page with comments. Oh, yeah, I'm sorry. Yeah, that last thing, we have 8 categories for murder generally. 6 for murder 1 and 2, and 2 for murder 3. So page 19. This is the enhancement section of the guidelines. And so we have, a lot of enhancements, but in this section under domestic violence, one of the things, just as background, the commission received a mandate from the General Assembly to create an enhancement for domestic violence, but it was just related to a child being, it's sort of a sight or sound thing, a child witnessing domestic violence. And the commission decided for that, the focus was going to be on providing treatment to the child and assigning those costs to the defendant. So that's the enhancement that the commission decided on. But because there's not a separate domestic violence statute in Pennsylvania, at least a crimes code offense in Pennsylvania, the commission used this as an opportunity to sort of tag DV cases and provide an enhancement for DV cases. So the definition that's highlighted is the definition that the commission created to identify offenses for which the DV enhancement would apply if the offense is against a family or household member. The question with this, or the issue that's been raised, is as written, this applies just to those completed offenses in those chapters of statute. And the question is whether this enhancement should also apply to inchoate. So attempt, solicitation, or conspiracy to those offenses. So if there's support for that, it's an easy fix. We can just add the inchoates in the definition. And there are other enhancements for which inchoates apply, but it's based mainly on the statute. Since this was created by the commission, then the commission gets to decide whether inchoates are included.
Does anybody oppose including the inchoate offenses under this definition?
I'd like to hear why people wanted to add them, if anyone knows.
I know Ryan had some discussion. I think we often hear about cases where someone is charged with either conspiracy or attempt, and it's a pretty serious crime in terms of domestic violence, and it would fall outside of what we have defined as completed offenses. So I think that's what we see in the data generally, and that's what I think we've heard. Ryan, did you have any? Okay.
And I have no issue with that. I mean, where my mind was going is when you have a multiple defendant and maybe someone is convicted of the conspiracy and someone is convicted of the actual doing. Do we want a distinction between those two individuals? But there's not. I mean, I'm just pointing that out. I'm not saying that I'm against it, but that I can see that scenario. I don't have a problem including it because then I can always deviate if I want to.
Right.
But that's just where my head.
One of the things that, Judge, to that point, if the commission wanted to consider it, the DV enhancement in that circumstance, if I can find it,
Is mandatory. I just realized. No.
No, it's plus
not.
2. So domestic violence. This is the domestic violence enhancement in table C in the packet.
Got it.
Is a 2 OGS increase. So if the commission wanted to, the commission could distinguish between inchoates and completed offenses, one OGS versus 2. But I know when we get into offenses like assault, where effectively an inchoate is built into the statute, for attempted assaults, things like that, it gets sort of muddled. So I guess, sticking with just 2 points across the board and including inchoates be great, and let the court exercise discretion.
Mark, isn't most places in the guidelines and even the code in COA's track.
They do. They do.
That, I think it's I agree that we can always distinguish
Right.
if it's somebody that
Right.
a bit player.
Okay.
Yeah, I don't have any problem. with it. I was just
Sure. Nope. Makes
Commenting.
sense.
Any other discussion?
So, let me see, the next one, this is on page 19, and there's several like this. So we'll start with trafficking in individuals in involuntary servitude. So there's two separate offenses that are part of the same enhancement, the same factors apply. If you look at that, and again, I should have probably provided the enhancement page to look at, but under these two offenses, it is possible to have a total of 6 additional steps based on factors. So I'll just read to you what the factors are for either of these offenses in terms of the enhancement. There's a 2-point increase, let's say for trafficking in individuals, if there is sexual servitude. There is a 2-point increase if the victim is 13 years of age to 18 years of age. And there's a 4-point or a 4 OGS increase if the victim is less than 13 years of age. So if you have a person who you have trafficking where the victim is less than 13 and there's sexual servitude, we're adding 6 OGS points, 6-point increase to whatever the underlying OGS assignment is. And we also build in that for when human trafficking, in the course of the event, there's kidnapping, rape, or IDSI, we create a floor of OGS 27. So if you start with one of those offenses, OGS 27, and then you add 6 points, you're up to 33, and OGS 33 based on the enhancement. And that's fine. It's just that there's going to be a couple of others where there are a lot of steps available. And the question is, should there be a maximum adjustment linked to the enhancement, or based on the nature of these factors, and that the General Assembly, in this case, required the commission to consider these factors in the enhancement, that we just allow it to play as it is.
Fine. Go ahead.
I would just say that we let it play as it is.
Okay.
I'll second that.
All right.
Anybody want to make any more comments? before we move on?
Oh, yeah. Right. Yeah. In this case, we'd max at 30 because that's sort of the threshold before you go into the murder category. But nonetheless, it would be, if you had lower ones, if it wasn't a 27 to start with, one of those offenses, have it. Okay. We will, we'll let that run. And I'm going to ask you the same question when we get to some of these other ones, just to make sure that the same response is given. So with that, let's move back to the other slide. So if we can turn here, this wondering where my document went. So the next one we have is the next page. Yep, page 20. You'll see there's the arson enhancement. And in this case, arson enhancements can increase up to 9 steps. So here are the arson enhancements, and you can see them there. And think of them in sort of couplets. So, so if there's 3 people in the building and it's an F1 offense, it's a +2. If there's 3 people in the building and it's less than an F1, it's plus 3. And the reason for that is the OGS assignments for those less than F1s are lower. And so the step up takes more space, or there's shorter distances between each. So the 2 and 3 sort of balance off. And then the next sort of couplet are greater than $1 million in damage, whether an F1 or less than an F1. And then the third is an incendiary device being used, so F1 or less than F1. So you can see if all 3 applied and it was less than an F1, there would be a 9-step increase. And if it was an F1 and all 3 applied, there would be a 6-step increase. But what's more common is, 1 applies. But again, and that's why we just wanted to confirm with you whether there should be any maximum adjustment, or if we just allow, whatever comes out. These are all statutory requirements for us to consider. Now, the General Assembly didn't say how much weight to give them, but this reflects what's in the current enhancement. So just confirming, or well, if we just leave it as it is, we get rid of the maximum adjustment. It's up to the court. You apply them all, and then you exercise discretion. It's just, is there any cap that you'd want to put on the enhancement for factors? Because you have and this is both for arson and aggravated arson, the same things apply. So.
Quick question. Can you just clarify again the subcategories where it's F1 or less than F1 and how those are the different?
Right. So for arson and for aggravated arson, there are different grades of the offense. And so if the grade of the offense is an F1, then the points we would add if these factors are determined by the court to be present would be those 2-step increases. And if the arson was for a lesser grade of arson, then it would be a 3-step increase for any of them applied. And you could get up to a total of 9 if all 3 of them applied.
Got it. Okay, so they're actually 2 distinct. I thought they were like 2, because I was like, wait, that adds up to like 12 or something. But that's
right. No, yeah, it's like I said, they're sort of couplets. It's either one or the other, but it's based on what the underlying arson offense is. And just because it wasn't complicated enough that way, I'll note that the X in the other column, maybe down a bit, the X in the other column reflects that we've already subcategorized this offense because there's other enhancement factors that determine the OGS assignment. So when you see an X in that first column, it means that the commission has multiple choices in selecting the OGS based on other enhancement factors if they're present. And then we add into it these sort of overriding or additional enhancement factors. So it's a pretty complicated provision of statute. There's a couple of others that have a lot of moving parts like this, but so whenever you see that X in the other column, you'll know there's sort of a 2-step enhancement. Yeah.
Quick question, just along those lines, just for clarification purposes. So for example, if you have, so you've aggravated arson, or I guess standard arson that causes serious bodily injury.
Right.
Okay. So then how does that change? So is that a higher OGS? Is that why that asterisk or still?
Yes.
Okay.
So the, generally speaking, the starting point for the OGS assignments is based on the elements that are in the statute and the grade of the offense. And then in this case, there are, I think, 5 different enhancement factors we're required to address. And so what the commission did for 2 of those factors is built those into the OGS assignment. So if this factor is present, it's like 1 step higher or something like that. Because it was, specific to that subsection of statute or something like that. So it was easier to just build it in, and then a person selects that as the offense of conviction with those factors present. And then these other provisions for enhancement are more, related to the nature of the offense or something like that. So that's why they're add-ons. And there's a couple of enhancements like that with like with the child pornography. There's a bunch of things, and some of them are easier to like just build into the OGS assignment as subcategories, and others you just have as like add-ons. And so this is an example of that. Okay. Well, if you're fine, I just wanted to bring it to your attention, but we'll just remove any reference to a maximum adjustment and allow the court to exercise discretion. So, all right. Moving on. When we get to page 21, this is sexual abuse of children. So this is the child pornography one. And two things that I'll mention. One is same kind of issue. We have a bunch of factors in play. This is a 5-step increase that's possible. And Ryan's getting us to the factors there. So you can see a number of the factors. The first two are built into the OGS assignment subcategorization. So we have different age categories for age of the victim, and we have whether indecent contact was depicted in the images shown. So those are built into the OGS assignments. You just pick the one that applies. And then in addition to that, there are 3 factors that are like add-ons. One is the nature and character of the abuse depicted. The second is that the child knows the defendant. And the third is the number of images. And so this morning when we had testimony from the AG's office, one thing that she mentioned, thankfully, was that the one add-on enhancement, the child known to the defendant, is a fairly new provision of statute. So we built it into this chart, but we forgot to put it into the text of the guidelines. So we'll add that to the text of the guidelines and reference this table. The other thing she mentioned, and we'll get to this when we look at specific OGS assignments, was we have 3 age categories to address this enhancement. So initially, when this offense was created and the commission was required to do an enhancement, the threshold was 13 years of age for the victim. And so we had victim 13 years of age or less than 13 years of age, and anyone 13 to 18 years of age, those 2 categories. When the General Assembly changed it and provided a lower threshold of 10 years or prepubescent, we then created 3 categories. That category, 10 to 13, 13 to 18. And what the AG's office was suggesting this morning was we did the right thing for the less than 10 prepubescent, but by creating 2 categories for the 10 to 13 and 13 to 18, she was suggesting that we should just collapse that into one and use the OGS assignment for the 10 to 13. That the 13 to 18, her suggestion was that's we should increase the recommendation for that. It's reduced from where it is now because we created 3 categories. So we'll get to that when we look at the OGS assignment, but I just wanted to tag that issue as we're talking about enhancement. So sorry about that. Any questions on this? I'm assuming no need to cap the number of enhancements. Good. All right. Thank you. So moving on. Page 23. We move into the prior record score. So the first thing highlighted is sort of the new approach to prior record score, that it takes into account the seriousness and the most serious prior conviction offense, and then the number in that same category. And as you heard this morning, and we've heard before, some people would prefer that we retain the current policy where you only take the most serious offense within an incident, but then there was also a suggestion that also counting consecutive sentences is maybe appropriate. And we were trying to get away from all of this because that complicates the process, and it also takes away from our ability to automate the process, part of what we wanted to do. So the idea here is that the new approach is different. It's about the seriousness of the individual, not exactly about just focusing on recidivism, things like that. So I guess staff is recommending we hold to what we have, but I wanted to make sure that we put this before you and you heard the comments. Okay, unless
No
there's
comment, any of that?
yeah, what we're proposing is that we just look at all prior offenses, identify the most serious, and then determine the number of most serious. So that could be multiple offenses within a single incident. And that was the argument that we should not do that proposal. We should go back to, we should retain what we have in place right now, which is much more complicated and is inconsistent because it's if there's a consecutive sentence, we count it, and if there isn't, we don't count it. And it doesn't matter if it's consecutive confinement or probation. It's just there's an indicator that, there's something more there. So we're trying to get away from that, which seems unfair and inconsistent and also complicated.
Is there, and I hear the complications of the current way of doing things. Is there a way to still address maybe some of the concerns that were raised about when sentences are packaged as one incident without avoiding that kind of double counting?
I think we have to do a better job of making very clear that courts should individualize sentencing and that parties should argue when something is not typical. So I think when, we're basing all of these guidelines on what's the typical sentence in the typical case. And there are plenty of cases like that where you might be able to argue these were in the same incident. They should be treated differently. But that's an argument for the parties who argue for a mitigated sentence or departure sentence, not to rebuild the guidelines to try to address that issue. And it also applies to juvenile adjudication. It applies to a lot of things we've talked about. So I think, our goal in this approach was to try to focus on what's typical and sort of common, and then encourage courts to think about, or parties to argue that something is not typical and that there should be consideration of aggravated or mitigated. They're considered part of the guidelines. In the appellate review of the guidelines, aggravated and mitigated ranges are seen as part of the guidelines. So I think there has to be a view that that's sort of a safe harbor as well. I think the standard range feels like a safe harbor, but I think we have to do what we can to encourage that aggravated and mitigated is okay too. And that also is true when we get into treatment and behavioral health and all those other things that were raised, that there are opportunities to consider that within the guidelines, but it would be in the mitigated or aggravated.
Mark, if this guy is a robbery and a criminal mischief, only the robbery counts.
That's correct.
Okay.
Yeah. And so,
We're not getting into the old totally concurrent.
That's what we're trying to get away from, all of that kind of stuff. Just keep it simple. Look at all the prior offenses, identify the most serious, and then we have 4 categories of offenses, like the top categories, crimes of violence. So if there's multiple crimes of violence, whether they're over a long period of time or in a single incident, they both count, and that puts you in a different category. But that's where you could argue, I think effectively, this all happened at one time, and it may be a basis for mitigation.
And I think the public defender from York was coming at us with that this morning. And I understand what she's trying to say. I do think though, that every situation is different. What's your definition of spree is probably different than my definition of a spree. And, yes, maybe it was that burglary, robbery, all one incident, but then maybe it was robbery, carjacking, robbery, a half hour apart, but all
Right.
sort of together.
And Judge,
So,
as you know, you could have a single incident, but you could have multiple victims.
Right.
And so this could be a very violent offense involving multiple victims in a single incident, which may be very different than, a single, multiple crimes of violence that are, maybe they don't merge, but they're sort of part of the same offense, same victim. And that's where I think courts can exercise discretion and parties can argue the point, but we have to come up with a sort of I think a streamlined and straightforward kind of approach to calculating it based on the typical sentence.
And again, if there's if there's two F1s, they both would count. F1, F3, the F3 wouldn't.
That's correct.
Okay.
That's correct. And that's different than the current one.
Right.
We would count all of that. And so, and so just as a reminder to everyone, the four categories, the top category is crime of violence. So that's POG 4. The next one is what we call serious offenses. So it's felony 1s and felony 2s. And then we've identified those F3s and M1s that are crimes against persons, like Article B offenses, firearms, there's serious offenses. They fall in that second category. Then category 3 is just all other felonies rather, and that includes drug felonies. And category 4 is all other misdemeanors. So it's pretty straightforward. And, if you're thinking about building an application to make this easier on the users to calculate the guidelines and so forth, it's straightforward, but you have all the information so the court can look at it and say, does this warrant mitigation or aggravation? Okay. So moving on at the bottom of this page, we might have some discussions about this. Bottom of page 23. The first thing we have is these both deal with juvenile adjudications and what counts, what do we count in terms of juvenile adjudications in the prior record score? The recommendation from the Juvenile Court Judges Commission was that we not include any adjudications by 14 or 15-year-olds. And we do include those at this point. So this would be a change in policy. The suggestion we heard was to do a carve out of that and to say for 14 and 15-year-olds, maybe we should include consideration of crimes of violence, that top category. And then the question is, if we were going to do that, so that would be a carve out, would that be then that those crimes of violence are treated like crimes of violence by a 16-year-old or a 17-year-old juvenile adjudications? Or do we do something different because they were 14 or 15 years of age? And one of the suggestions during the Erie hearing was that maybe you draw a line at maybe age 21, where we say, well, these 14 and 15-year-old crimes of violence, we're going to sort of keep active because if this person's in the criminal justice system before the court before 21, the person will have a prior record score based on that. But if we get past 21, maybe they would not be considered at that point. So those are some issues for you to think about or consider. But as written right now, any offense by a 14 or 15-year-old, any juvenile adjudication would not count. And I think the argument was create some kind of exception around violent offenses, perhaps just the crimes of violence by 14 and 15-year-olds.
Discussion?
So the proposal for crimes of violence for kids above 15. Those
They count, and then there's a lapsing
the
provision,
gap,
but it's a gap at
15 years crime.
yeah. And I should say, and this was during the Pittsburgh hearing, I believe, that we did hear from several DA offices in Western Pennsylvania with concerns about having any lapsing of crimes of violence, whether juveniles or adults. And so they would have suggested or recommended that we just eliminate the lapsing provision for juvenile adjudications for crimes of violence. And I believe as part of their testimony, they would have extended that down to 14-year-olds, that any crime of violence by a juvenile 14 or older would always count.
I'll speak to it. I can understand the concerns expressed. And I think it's a issue that we're constantly dealing with when you change or the law applies depending on your birthday.
Mhm.
You can have incredibly violent 15-year-olds and 11 months and 29 days old
Mm.
that will get treated differently than someone who is one day
Yeah.
older.
Older. Mm.
So the 15-year-old, I understand again the reasoning for adding. I might not necessarily agree with the 14-year-old. I mean, the question is, where do you always draw the line? Is it 14? Is it 15? Or 16? My experience has been I've seen some of the most violent crimes with the most serious ramifications committed in that 15-year range, not so much as the 14-year range, but certainly in the 15-year range. If it's going to be added or if we're going to do anything about it, I think it has to be more consistent with the lapsing and not just at 21. I'm pretty adamant about that. 21 is not enough time to have something lapse, particularly if someone has, let's say, committed a murder and they're being treated in the juvenile facility. Chances are they're going to be released at 18, but they still have jurisdiction to 21. So I think that time frame is way too short. And if we're going to do it, it should be consistent with whatever we do for 16 or 17-year-olds. I don't have a strong position either way. I think certainly a compromise might be you add 15, but keep 14-year-olds old. And I'm not just splitting the baby. I'm just saying that's based upon my experience in terms of what I've seen, but I'd be certainly curious and what other jurisdictions have seen with crimes of violence by juvenile.
And I'll just add that one of the reasons that there was discussion of 16 as the new threshold was because of the transfer provisions and the different ones for certification at 14 and for direct file at 15. And we discussed this morning, and I know Judge Marsico had an exchange with the AG's office about this, that, you don't want to create a disincentive or an incentive for transfers because, build all around the prior records. And that I think that concern has been raised by other prosecutors in terms of, we may think that we can continue to work with this individual in the juvenile justice system, but that doesn't mean it's like an all or none proposition. That doesn't mean that does mean that then we lose the opportunity to consider this if this person returns back in the system, except as aggravating circumstance departure. So I understand that logic, but I think the Juvenile Court Judges Commission was saying, look, juvenile courts are different. If a person is retained in the juvenile court, we should give some latitude to that determination and some, sort of respect the province juvenile. So those are the arguments we've heard. Yeah. I mean, when we've had those discussions, we've always had 14 as the threshold,
Right.
But part of the thing in discussions over the years about changing that or looking at different policies was really informed by the Juvenile Act and the transfer provision and the different provisions for 14-year-olds versus 15-year-olds when you look at the certification versus direct file. And it sort of gets to the judge's point that at 14-year-olds, there's there's a greater engagement of the juvenile court in reviewing sort of the case as a whole to make a determination about a transfer, whereas at 15, there can be a direct file and the only remedy, if it goes, is a decertification. So 14, 15-year-old crime of violence with a 10-year gap. Yeah. And the gap, I'm trying to think, we'll have to look at the language that we use for gap. Because the question would be, when do you start the crime-free period? Do you start, from release from placement, or is it, yeah. Because you could link it to juvenile court jurisdiction. You could, you'd have to decide, or you could link it to the date of the disposition of the case.
We're looking at that concept of the age, the date of disposition could hold. Because your point is that'll take them through to 24, 25. So regardless of, you have to have something that's measurable. But if you went in the position,
Well,
But-
if you want to go that way, then you probably just do a decay and make it 25. I was thinking of seeing some evidence that this individual hasn't been in trouble for a period of time to get rid of that crime of violence. In 10 years, tracks a lot of what the legislature's done recently with clean slate and all that stuff.
the decay
you-
after 10.
Yeah,
I
but
do gap.
you could
That's
do,
nice.
but you could do gap and set a time, sorry, an age. And I know age isn't great, but because of the complications of figuring out when you start the clock, if you just say for 14, 15-year-olds, it's a gap, so it has to be crime free, and it's up to 25 years of age is when we look if you've been crime free during that period of time. What happens if they're not crime free? Is it an all or none proposition, or do you start the clock then? But they'd be, wow, yeah, I don't know. Work is all.
I was going to say, I think the simpler thing for juveniles is just an age, and we've done that in the past. And I just wanted to add, the reason why I said, I was on the fence, or I could go either way with the 14 and 15-year-old, 14 versus 15, was actually because I knew the direct file, to correct me if I'm wrong, that starts at 15.
It does it.
So that's why I was sort of suggesting, if we're trying to be consistent, we maybe still let the 14 years old out of it, but include the 15. But, and then I still think that's consistent with our belief that and again, it may just be my experience, but in all likelihood, the 14-year-old is being influenced much more by, let's say, a 16 or 17-year-old, where somehow, and it just may be my experience, and I'm wrong, that by 15, you really have kids in high school. Some 14-year-olds can still be in 8th grade. And I think they're just more impressionable. But again, it's my perspective that 16, 15-year-old, I think are different than 14-year. So I'm just throwing that out there. I think in some ways it's cleaner if we do it at 15, consistent with everything else.
You're the chair judge, so you get to decide.
just so I understand it, so the current proposal is to start at or what you're suggesting, Judge, start at 15 and then have a 10-year gap at 25.
I'm saying I can live with either, but I think it may be more consistent with what we already have in place at 15. And I was just throwing out off the top of my head why I think there's a distinction between let's say a 14-year-old with a crime of violence and a 15 and 16-year-old. And I kind of put almost 15 through 17 in the same category. But again, that's just my professional experience and knowledge. But we're not choosing between right now, but that it would be my proposal.
Yeah, the only other, factor, I guess, that we have out there that's not a good fit, but clearly, if you look at the Miller cases and the thresholds for purposes of murder one and murder two by juveniles, they couple together 14 and 15-year-olds and 16 and 17-year-olds. So they're in like two different categories like that. So, at least we have, the one category, 14 and 15. The question is, do you see it as a whole, or do you see it as just 15 or 14 and 15? So
I'd like to hear from our prosecutor
Couple questions.
if I could.
Yeah, a few questions I have to start with. I think it's important to recognize, well, this is more of a statement. It's important to recognize that regardless of whether or not an adjudication counts on a prior record score, the adjudication still exists.
sure. And it
And-
can always be considered by the court.
And it
The
can,
guidelines
and
are-
it can always be considered by the court.
Right.
So let's say an individual at the age of, I don't know, 28, commits a robbery, something of that nature. The judge or the court can certainly take into consideration the fact that when they were 14, maybe they committed a robbery at that age as well, or we'll say 15, and can take that into consideration as they would anything else, any other sentencing factor, right?
Right.
So I just think it's important to recognize that. So that's sort of part one. So then we move into the prior record score side of this. So when I know that one of the concerns that I have is the fact that, and we try to spend a lot of time as prosecutors. I know my association does. In my office, we certainly do. We try to read all the data. We try to understand the studies because it's all geared towards public safety, right? And so and sometimes, our historical belief of what might be the way to do things may not actually make the public safer. And so these are things that we're all working on, I think, right now, the collective we in the criminal justice system, right? And so when I think about this issue, this is a difficult one because I know that in my office, I've seen, and we have a pretty busy office, 14, 15, 16-year-olds, sort of like Judge McDermott said, where how do you pick that month or that day where they then wake up that next morning and become, something else, that are extremely violent.
Mm-hmm.
And regardless, and we're very cognizant of the factors that may lead someone to commit a violent act, to be violent, whatever that might be. There's a whole, a whole list of different variables, from trauma to whatever it might be.
Mm-hmm.
And then turning towards public safety, my concern is, to start with, I think no matter what, that the age 21 has to go with regard to prior record score not counting. Wasn't that the initial recommendation? Was it when they hit the age 21, then
That's just for misdemeanors.
that's just for misdemeanors?
I think I would have to check when we get to the lapsing provision, but yeah,
Okay.
it's just, there's different categories for
Okay.
different seriousness of offenses.
Is there any data to support a time frame? If an individual, let's say at the age of 15, commits an F1 robbery, is there any data to support the time frame that needs to exist to put that person statistically in a place where they are much, 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 much less likely to commit another crime of that nature?
Well,
Exactly.
yeah, Right. And the general rule, but this is not necessarily for juveniles, but the general rule is 10 years, but it depends on the nature of the offense. So for more serious offenses, it could be longer. That's Al Bloomstein's work. But for juvenile adjudications or juveniles, you have, first, it's a very small group of people. So getting, good data on that's always difficult. But you have the whole issue of brain development. And so I think when we talk about juveniles, a big sort of threshold that we think about is 25, because, give or take, that's sort of the point at which you're getting to saying this person, that has a more formed kind of view of, less whatever. It's just, I think that's what generally is what we see in the research. But I don't know that there's any research that's specific about like F1s by juveniles at what age and when,
Just a crime of violence, a crime.
yeah. And that's why we, when we get to the lapsing, we have different categories. So the 21 is for the sort of the lowest level. Then we have 25 for another. And then we have for crimes of violence, we have the gap provision where we say it has to be a crime-free period, not an age limited thing.
And
so we've tried to radiate that.
And in one of the other sort of factors here in my mind as a prosecutor is when I think of this age group, I think of the crimes they're committing. I'm thinking about the fact that we don't have bed space to send someone to. Okay, so are these juveniles, you're looking at the age of 14, 15, 16, 17 that are committing, and we have juveniles that commit crimes of violence or are alleged to have commit crimes of violence, that we can't find a bed space for them to go to keep them off the street where they're actually receiving the services that they may need to receive. And so when we're looking at this group, I'm viewing it through the lens of a group that we don't have a lot of the best data for, that, are we even giving them, are they getting the services they should be getting? And when I say bed space, I specifically mean secured bed space. And so I guess with all that being said, I would want to see something where at least there's a gap, or there has to be a crime-free period for these juveniles.
Right. And with that, Judge Marsico suggested that you use a gap, that for 14 and 15-year-olds, the gap be 10 years. And we can talk about like how you measure that or what the anchors are. But, does that make sense to you? Because the current policy for 15 and older for juvenile adjudications is a 15-year gap period. And I'm guessing, and I'll have to look if we have a specific definition, but it says 25 years. Let me find it. Following completion of a 15-year crime-free period since the last adjudication or conviction, remove prior adjudications for crimes of violence. So the crime of violence gap, which is crime-free, is a 15-year from the last adjudication. That's what we have for juvenile adjudications if you're 16 years of age or older, 16 and 17.
And so really the question is whether or not that also applies to 14 and 15-year-olds, correct?
That's exactly it. And what the judge mentioned was, as an alternative, it would be a 10-year instead of 15.
Well, I think, just for me personally, obviously I defer to my colleagues up here on what their thoughts are, but I think that it's important. I would actually recommend to just extend that to the 14 and 15-year-olds.
Okay.
And that's based on what I see in my office.
So another option is just treat the 14 and 15-year-olds for crimes of violence like we treat the 16 and 17-year-olds.
Which is the 15-year.
15-year
Yeah.
crime-free period from the date of the adjudication.
just to chime in here, and I appreciate DA Sunday and all the considerations you raised in this, and it's a really challenging situation that we have to deal with kids. I know myself and Judge McDermott have to deal with this all the time in Philadelphia. And I'll just say it from the jump. To me, when we have any 14, 15, 16-year-old committing crimes of violence, like that's a policy failure, right? It's a policy failure when we're at a situation like that. And so I'm of the mind of what can be done to try to save that kid, and knowing, right, that there's times where it's just going to take them to have to age out of that, right? So all that to say, if there is a compromise that we have to figure out with this, I would be in favor of the 15 and 10-year gap that was put there, just to at least try to create some room to say, hopefully, we can give these kids a chance to not fall, like keep following this pattern. So.
I was just going to ask Judge McDermott, if it was limited to 15, were you recommending gap or decay, and for how long? Or
Well, I think part of I'm going to backtrack a little, is we want to try to be consistent. And you made an excellent point by talking about how first degree, it's 14 and 15 are lumped, and versus 16. So, and I was thinking the direct file juvenile and hadn't thought about that. I think it's a difficult situation. I want to echo that, because what's clearly on my mind, because it was on the news last night again, is we have groups of teenagers who go into stores and destroy the store. And in the course of that, they commit crimes of violence. They hit people, they beat people, or we see them, the videos on the subway. It's a problem. Yet, okay, so there's that one thing. But I want to be able to say, look, we're evolving in terms of our response within the criminal justice system, and we don't want to give up on these juveniles. So for me, if I go consistent with that philosophy, then okay, I'm fine with the 14 and 15. I'm fine with either of it, but if we want to be consistent with the first degree, then it's 14 and 15. If we want to be consistent with direct file juvenile, it's 15. I'm probably more in favor of a less of the gap. I like the 10-year proposal, because that's also saying we're acknowledging that there's still a difference within these parameters of juveniles. So I can be convinced, but the harder decision for me is, do we go consistent 14 or 15, or do we forget about the 14-year-olds for now, let that not count and stick with the 15? And I think I'm not going to repeat myself again, but we have guidance within our own statutory constraints and or guidelines to choose either one.
either one, right?
Point on that, and I'm not saying whether it's right or wrong, if we eliminate the 14, like the standalone 15.
Yeah.
I don't think.
Right.
Or way we can go the Pennsylvania statutory work. 14-year-olds are subject to trans.
Well, so considering right now in the proposal, we're not including these at all. It sounds like at least there's consensus, I guess, around, let's say 14 and 15-year-olds, including limited to crimes of violence, and at the sort of the short side, a 10-year gap. And that could extend to a 15-year gap, or something akin to how we're dealing with the 16 and 17-year-olds. So I think that's progress in terms of consensus on some kind of change to what we have. So I'm going to turn it now to the judge as chair to
I'm comfortable
guide
with
us to
this.
the end on
So
this.
I heard a lot, and I leaned over to DA Sunday to ask his experience with 14 to 15-year-olds. We heard a lot in our public hearings from both sides, and I think from what I'm hearing today, the concept is if we're going to do this, I think it makes sense to do the 14 and 15-year-olds together. That's what I'm hearing overall. I know there's some debate, but, and again, there's going to be the person who's 16 who's like, well, if I were a month earlier. So there's always going to be someone who's going to say it would have been 10 instead of 15. But I think it meets some of the concerns of those who were raising the fact that if I have somebody, you know, who doesn't have a prior record score for a violent offense because they were 14 or 15, and when they come in front of the back end in 18, the court can't use that for prior record score calculations. I think we address that concern, but we also address the concerns with the brain science, the age, and then we're also in conformity with some of the other statutory provisions. So that's what I'm hearing. So is there anybody who would disagree with 14 and 15 and 10-year gap only for violent offenses? If anybody wants to discuss more or is in opposition to that, now's your chance. And if, you know, between now and tomorrow morning,
Tomorrow.
people do some
Right.
research and they come
There
up
you
with
go.
something, we can always revisit it. But that's what I was hearing based upon this, coupled with what we've heard from the public hearings.
Okay. Well, I'll at least put that in the draft and we can decide for sure tomorrow. So let's hit one other issue of juvenile adjudications. And this is under the proposal.
Before we do that, can we
yeah.
hop in for a 10-minute
Sure.
court reporter and bathroom
Yep.
break?
Yep.
Okay. Let's just do that. Unless there's something, if there's a segue briefly before we,
Just this one issue,
sure,
and then
let's
we
do that.
this is just about, it's about juvenile adjudications and it's about what we count. Under the current guidelines, for 14 years of age and older, we include only certain misdemeanor 1 offenses. We don't include misdemeanor 2s or 3s. And the misdemeanor 1s we include are basically those involving death or substantial injury. So only limited M1s count, and then all felonies count. So on juvenile adjudications. Under the proposal, we broaden that to say all M1s and all felonies. And one of the comments we received from the public defenders, many of the public defenders, was, you know, we'd sort of prefer to go back to the current rules in terms of just limited M1s count. And I think we do have a mechanism now that we could accommodate that, because when we came up with the 4 categories of prior offenses, we sort of carve out misdemeanors and that are like non-violent misdemeanors in the POG 1, I guess, right? So what I'd suggest is, instead of saying misdemeanor 1s, what we do is we say sort of the misdemeanor 1s that are not, we exclude from the juvenile adjudication the misdemeanors that are in POG 1. So that means the only misdemeanor 1s that would count are the more serious or violent misdemeanors. So if there's no objection to that, we'll make that modification to limit the number of misdemeanor 1s that are considered in the prior record score for juvenile adjudications.
I have a question.
Yeah.
Historically, possessing a weapons is considered a crime of violence, although technically under the code it isn't.
Right.
So I just want to make sure weapon offenses are still included.
It will be included, because the 3 categories of misdemeanor 1s that would be considered are Megan's Law, firearms, and personal injury crimes, or crimes against persons, Article B crimes. So I think that captures all 3 of the M1s, serious M1.
Thank
And-
you.
And if you just go to page 25, wrap that up, because I think that'll take 30 seconds as I reviewed it.
We'll see. You got us into this, Judge. Yeah, this is about removing revoc as the label, and then just the defining the prior record score 4 as multiple crimes of violence. Prior records.
We've
Oh,
discussed that before.
Well
Any other-
done. Thanks.
I thought we did all of that.
Oh.
That was that. Did I?
Okay.
Well, then we'll come back to it. Maybe I
Okay.
scrolled. All right.
Okay. Okay, go ahead.
I thought we did, but no.
Well,
Okay.
let's get it out of the way. So 24, the first one is about the issue of burden of proof. We put in language that would put the burden on the defense for determining a lapsing provision. There's a lot of reasons why maybe that's not a great idea, especially because they don't have access to a lot of the information that's necessary. So I think it makes sense to remove that language, have the court make a determination, and clearly the DA has the burden to show the prior record score, and there can be a determination by the court about whether something lapses or not. So I think that makes sense if it's okay with you to exclude or remove the burden on the defense. And the next thing, the juvenile adjudications dealt with what I just discussed for the judges thing about the focusing on the misdemeanors that are in POG 4. So we're good. Yeah, that was raised this morning and previously, and I think it makes sense. All right.
All right. Yeah, then we're going to take a 10-minute break.
Sure.
And I know that ends up being 12 or so,
Right.
but let's shoot for 10.
And we'll
Okay.
come
Thanks.
back to page 27. Thanks.
I did. Pops up.
All right, we are back from our break and I'm going to turn it back over. I believe we're on page 27 is where I have since I did so well with the page numbers last time, I believe that's where we're starting from. So I'm going to turn it back over to the executive director.
Thank you, Judge, and good afternoon again. And some of you don't have page numbers, so for those that do, we are on page 27. We're moving into the guideline sentence recommendations, and this picks up on on one of the issues I talked about before about sort of separating out offense-specific recommendations from judicial proceeding policies, benchmarks, whatever we end up calling that. So that's why in these general provisions on page 27, we're just sort of trying to clarify that and move the stuff about judicial proceedings to the back of the document. So these are just sort of technical changes that you see on page 27. Moving to page 28. Again, as part of this, just making sure that these are the offense-specific standard range recommendations. So just a text addition there. On page 29, this is where, and I'd encourage, if there's another term that we can use, but we were trying to distinguish between this new term of administrative probation and any other kind of probation. So I think, at least for purposes of distinguishing it here, we were including reference to standard probation, but we could just refer to it as probation, but I don't want to confuse people. The difference here is at level A, which is restorative sanctions, we are saying, as necessary, you may use administrative probation to facilitate the use of those otherwise sole sanctions. But when you get up to level B, which is the probation level, we are talking about typical probation, standard probation, the one that has supervision provisions like curfew and other things like that, other conditions. So anyhow, that's why we were trying to distinguish the two, and we're suggesting that we insert the term standard probation. But yeah.
Quick question, Mark.
Sure.
Would you agree with me that that part of the policy behind this is to free up probation departments to be able to focus their time and energy on individuals that require more supervision, a more intensive supervision, and to kind of like keep them away from having to spend time with people that don't?
Absolutely. And to sort of right size the duration of probation as well. And you've heard that, you know, from probation for many years now about concerns about having these very long periods of probation that are counterproductive in a lot of ways. So it's not only, you know, targeting and trying to figure out when to use it, but also what's the right duration. And that's where, again, the general recommendations are about trying to get back to, you know, 2 or 3 years or, you know, aggregate terms that are shorter that seem to be consistent with the research about what's necessary and appropriate. Okay, well, we'll move on, but if you have any suggestions about whether we use the term standard or some other thing, or we don't use it, or we just refer to maybe section 9763 where it has the conditions of probation under B of standard probation, we can do that. But we do want to just make clear what we're talking about at level B and how it's different than level A. Moving on to the comments, let me just look at them. So now we get into the issues again that the ACLU raised. So the first on page 29 is just a refinement of the language regarding fines, where you take into account the defendant's ability to pay. Next is restitution, where we include the reference to sort of the 2 types of restitution, clarifying the use of restitution. And then we will delete the reference to costs in this section and to fees. So we've talked about that before in the definition section, and now we put it in the text itself. Continuing several pages back, page 35, I believe, is the next page. We'll soon be looking at the matrix for a couple of minor changes suggested to the matrix. But one issue that was raised by a number of defenders, and I think actually was echoed by a number of DA's offices that we heard from. And I think the commission has talked about this before, that in some of these areas where we're trying to be much more targeted, there's no harm in giving a little bit more latitude to the court and or to the parties in terms of aggravating and mitigating circumstances and ranges. And so one of the suggestions to again give just a bit more latitude is at level D and level E, slightly increase the duration of the aggravated mitigated range. So at level D, increasing it from 4 months to 6 months, and at level E, increasing it from 6 months to 9 months. That gives a little bit more movement in terms of aggravating and mitigating circumstances. And then if you look at the other comment on page 35, we're just correcting the example that takes into account a little bit longer range. So moving it from 66 to 69 months when we're addressing level E. And on the next page, moving the example from 54 months to 51 months as an example of level E. So I don't know if there's any comments or questions about slightly increasing those, but we'll have another chance to look at that when we look at the matrix.
Any comment? Where does that fall in the footprint of the current?
It
Right.
actually, I think it's with right now the guidelines, the ag MIT ranges, I believe, are broader.
That's what
But
I
let
thought.
me I did have an old matrix. Here we go. So under the current guidelines, we have plus or minus 3 months up to an OGS 5, which includes both probation and county confinement. Then we have 2 cells that are primarily county confinement of 6 months. We have 1 cell that's it's both county and state confinement of 9 months. And then everything else is 12 months. So we're certainly
Still
using the
within the
same.
footprint.
We are.
Okay.
We are. We just are using them in different areas.
All right.
Okay. So moving on, page 36, when we get to the reasons for the sentence, I want to say that we've heard, I think a lot of positive comments about including these and about the nature of the reasons. a number of people wanted us to consider adding additional reasons, and I appreciate that. What I might suggest are a couple that have been raised and for the commission to consider. When we listed the reasons for sentences, we came up with two categories based on the statute. One is nature and circumstance of the offense, and the other is history and character of the person. So in the nature and circumstance of the offense, there were suggestions that we consider. Let me find these. Suggestions to add multiple offenses in a criminal incident as a reason for a sentence outside of the standard range, linked to the nature and circumstance of the offense. So taking into account explicitly or providing it as a reason that there are multiple offenses within a criminal incident. And we've talked about that for purposes of concurrent consecutive and other things like that, but it has been recommended also as just a reason for the sentence. So something to consider. I overlooked the first thing I had in reasons for the sentence. When we were in Philadelphia, one of the individuals testifying suggested that just the way we drafted the language for the reasons for sentence sort of combined two things and was less clear than it could have been. So in this section, we're first saying that courts are required to provide reasons on the record and to report those to the commission. And we've sort of expanded the request for that. It's always been for departure sentences. And what we've added to that are aggravated and mitigated sentences because we want sort of a feedback loop on the guidelines. And then because of the new OGS assignments for murder 3, we explicitly are asking for comments about sentences for murder 3. So those are so basically anything outside of the standard range, we're asking courts to state on the record the reason for it and to provide those to the commission. And then separately, we're providing a list, sort of non-exclusive, right? A list for courts to consider. And at least during the Philadelphia hearing, there was a concern that courts had to go through the list and identify, make a statement on each and every factor, or identify why it was or what was not being considered as part of it. So we just wanted to reframe this or rephrase it so that it's presented as two separate issues. One is you must consider, put on the record, or you must put on the record and report to the commission the reasons. And then separately, here are some reasons you might want to consider and any other ones that you think about. So that's what that section does. Unless there's any comments on that, the next section dealt with the history and character of the person. And it was suggested that we should explicitly add into this one treatment for substance abuse or behavioral health issues. And that was raised certainly by a number of people that wanted to make sure that that had more prominence as a reason for a sentence. But it was also raised because the issue was raised that there may be cases where you actually do impose a longer period of probation or of supervision because you want to make sure there's adequate time for appropriate treatment intervention. And so linking the two of those things together as a reason would be important. So those are two additional factors that were suggested to add to the reason. And I think we've heard others, but those were two that if there's not any objections, we'll put them in the list.
Mark, can you state again specifically the one pertaining to substance abuse?
Yeah, this was raised in two different areas. In one area, there was just the sense, especially when we're recommending confinement where there are many cases where people receive probation in the past, the argument was a lot of times probation was given so that people were in treatment or were placed in treatment or we were dealing in the community with behavioral health or drug and alcohol issues. And so they thought that it's important that that be one of the reasons for a sentence that's a mitigated or aggravated or departure sentence. And then the second issue raised, and I believe this was from PDAA, was there are times when the duration of probation might be longer than what's recommended. And sometimes that's because of the clinical prescription for treatment or something like that. You just might need more time for treatment. And therefore, using that as a reason for an aggravated or departure sentence would be appropriate.
Okay. And the reason why I asked is and I agree with all of those reasons. I just didn't want there to be any confusion because voluntary intoxication is not a defense.
Right. Absolutely.
Anything
Nope.
other than from first degree to third degree.
Yeah.
And I just was thinking about the interplay there.
Yeah.
When you were
And
reading
this
that.
is, of course, the guidelines are based on already having the conviction and then
Mhm.
talking about the guideline recommendation. And this is recognizing treatment's part of it. The other thing is, within these guidelines, we try to make clear that consistent with the current guidelines, there's a trade-off available for confinement sentences, and particularly for county confinement sentences. What was county intermediate punishment, what is now restrictive conditions of probation remains as a trade-off for confinement. And so that has, sort of two steps in place. One is to do a clinical assessment and determine if the person's drug dependent, and then you can use a clinical recommendation in lieu of confinement. So we could be recommending, 9 months or 12 months or something, and the clinical recommendation may be more or less than that, and that just sort of takes the place and is seen as a standard range recommendation. Separate from that is if the person's not drug dependent, there's a 1-to-1 trade-off between what we're recommending as confinement and what can be used as restrictive conditions. So those things are still in place, but we had to emphasize that in certain public hearings about, those treatment options are available, problem-solving courts are available, and just a trade-off with restrictive conditions is available. So when we're saying jail is the recommendation, it's not exclusively jail, it's jail or the trade-off with the use of restrictive conditions. And that's, I think, an important distinction in terms of when people say, oh, it's all about jail. It's not. It retains the same character as before, that there's a trade-off with these restrictive conditions. What we're saying is those shouldn't be used in lieu of regular probation. We shouldn't be putting more conditions on people when we're recommending regular probation. The restrictive conditions either are used because there's need for more intensity or because you're trading it off with incarceration. So anyhow,
And these are examples.
these are absolutely.
Okay.
And
Oh, yeah. Yeah. Yeah, I'm glad you raised that. So in the there weren't any changes proposed to this, so we didn't spend any time on it. But under the standard range recommendations, we have a provision that deals with that standard range, what we're recommending, and it says treatment alternatives, including medically assisted treatment and behavioral health therapies, when clinically appropriate, may be considered to address substance use or behavioral health issues. The specialized jurisdiction of problem-solving courts is authorized by statute, provide an avenue for the use of court-supervised individualized treatment programs and services, other treatment programs such as those described, and we talk about the county and DOC programs may be considered. So I'm not sure if that gets to autism, and maybe we can add some language that's beyond, yeah. Yeah. Right. Well, I think we could broaden that language because I don't think autism necessarily fits into either of those categories, but it's probably an appropriate addition. So we could add that to both the treatment and behavioral therapy sections. Thanks.
I had a question. I had asked you about this prior to today. And I'm curious how other jurisdictions work because I put my reasons on the record, but on our sentencing forms, there's not a place for it. So when it's going into the SGS web, am I alone in my county or are there other counties? Is there anything we want to say about documenting it on your sentencing form or?
Right. And
Because, yeah, because I think staff sometimes are making educated guesses or clicking on negotiated.
yeah, so the way our application works and the way it's intended to work, and Christy could talk about this, but one of the things we've discussed in the next gen is to think less about a form and more about a report. So that, if a form is, rigid and you're filling in a box. And we do have a box available, and in SGS Web, we have space available and we have checkoff lists for reasons for the sentence. But you're right, that might, escape some people, but in the new one, we're thinking more in a report thing. If you think about like, here's an issue and you're filling in the space. So it just adjusts to what you need.
That's on your side of things.
That's right. But that would also be available in terms of a pre-sentence document that could be used by court personnel to write reasons or if it's electronic to check boxes for these or other reasons. So one of the things we're trying to do is make sure that SGS Web or whatever we call the future one is not only builds in this list that you can just check boxes and add others, but also that it's available on a device so that you can use it in the courtroom or PDs can use it as well as DAs or probation. So we're trying to make it more accessible in terms of putting stuff right in instead of writing it on a paper form and then trying to enter it later or trying to figure out what the judge said.
I think, you say state on the record, that's the easy part.
Yeah.
The hard part is getting it into
Right.
whatever we need to get it into,
Yeah.
whether it's a report or, now half the time I forget, usually I just write down plea negotiation, little
Right.
box on the bottom of it. Am I doing that? Is someone in the courtroom doing it? Is someone afterwards doing it when it's submitted? I think that's,
That was my question. Should we speak to that at all, even in terms of recommendation?
Well, there's two things we have here. In addition to the list of reasons, which we will build into SGS Web or whatever we call it, and we can see about making that available on whatever form is used by the court or by court personnel to track what sentence was imposed and any reasons. We also list that under reporting of reasons, when the court imposes a sentence, murder of the third degree, or imposes aggravated and mitigated sentence, or departs from the guidelines, the court shall include the reasons on the guideline sentence form and electronically submit the information to the commission. So we have the provision that says that. The question is, what could we do to make this fit your view of the world? What is it that we should be
Well,
preparing or
I don't know that you should be preparing anything. We need to do it on our end, and whether it's when we
Right.
go out and educate the bench, say, we all are aware we're supposed to put these on the record,
Yeah.
but it's not on not all the judges are thinking, therefore they hand over however they do it electronically or with the actual sentencing
Well-
form, and then somebody else generally is submitting that data.
Yeah.
And I know county by county, that's different, but maybe we just need to make sure they understand that putting it on the record, no one's pulling my transcript to look at the reason that I put it on the
Right.
record.
Well, I think what we want to move towards, and we've been working on this, but we have to continue to work on it, is we don't need all this redundant entry. You know, we're trying to consume stuff that's already in the system from AOPC and others to like load our stuff. And then what we're trying to do with the new application is make it way more user friendly, like just in terms of, you know, pick the offense. Here's going to be a pre-populated list of like the enhancements, like check the boxes that apply. And then when it comes to you imposing the sentence for reasons, we're going to populate this list and have a space for others that you just check boxes. And so you can see, like with our application, we're going to try to make this as user friendly and as like available as possible. But what we have to get to is people then using the application and not like printing off stuff, writing on it, then having someone else put it in or whatever else. And that's where Ryan and his whole staff have been working with counties to like rethink their process for preparing guidelines and submitting information so that the people that are actually responsible for it or making decisions can just easily get into the application and do it. And so that's why when we've talked about rebuilding this application, we've talked about, you know, we know it's based in JNet, but there are ways to do it, sort of do aspects of it outside of JNet so that in the courtroom, you could have a, you know, a laptop or a tablet, and you could just do it on that device and push it to, you know, JNet, or defenders and others could have access in a non-secure way to some of the same information. So we want to, you know, we have to continue to work with counties on this, but I think there's a whole lot more that can be happened to again, reduce some of these redundancies and just make it more seamless in terms of having this information readily entered instead of multiple steps.
So what I'm hearing as your answer to the question, which is
Frustration?
No. Exhaustion. No, I'm hearing it's not something we want to write in anywhere
No,
here. It's
I don't
just
think we
about
can.
making sure when we're going to counties,
Yeah.
their understanding and however the system works,
Exactly.
and as it becomes more user friendly.
And Judge, you're aware of this, and I know we heard it today, but we've heard it throughout this period of time. I think there's a lot of things that we're hearing positive about this approach, but I think everyone uniformly says part of this is going to be a lot of training and education and like hands-on work with this. And I think that's just another opportunity to really try to encourage people to like think digitally, like think about using the application instead of like getting books and writing things out. So we need to work on that as part of the education now.
Thank you.
I'm going to echo Mark's comments because I don't see it as a problem now. And I don't know if it is a problem throughout the state, but less is more when people are putting information in forms. And to me, if it's a big enough issue, the way that gets handled would be the way that it's handled when someone makes a mistake on the form and the law clerk, in my case, it's the law clerk that does them, says, you can't enter that. So, I mean, if it really is a big problem, what I would say is build in something that when it's a deviated sentence, you won't accept the completed form until something is checked. That to me is the simplest way. That's the easiest way that anyone who's doing them. But to continue on my less is more, I don't want the parties getting access to entering any type of information on the form because it's my sentence and it's going to be, you know, my explanation.
Yeah.
So,
That's
I
great.
mean, but that is one way that you can, if you need more information from us and we're not complying, when I say us, the royal we judges, that's a way to do it.
Judge,
I don't know if you can build that in.
I appreciate that. And look, we have for many years we've built error checks into our system, and at times that's been I guess counterproductive because, you know, if there's missing information or it's an illegal sentence, that sometimes creates a little bit of a roadblock in getting the stuff to us because sometimes staff will not go to the judge because like I'm going to be calling into question the thing, or you know, some bureaucrats told us this was illegal or whatever. So, you know, we encourage people to blame the commission, blame us if you can't enter it because it's an illegal sentence. But and it's up to the courts to decide how to remedy that or if it's truly illegal. But if something's longer than statutory max, it's just not going to allow you to put it in, or it's going to give you an error message until it's corrected. And so we've done that for a long time. And the other half of that equation is helping to make sure we work with counties to resolve those issues so that we actually get the data. Because sometimes they'll just be hanging out there because they can't enter them. And it might be missing information, like a missing SID or something like that. So anyhow, that's Ryan's job, but a lot of progress. And let me just point to Philadelphia. I mean, we've heard about underreporting of cases in Philadelphia, and I think Philadelphia this year is at like 100% or something pretty darn close to that. And that's a credit to you and your bench, Judge Clemens, all of the staff. I mean, it's a huge turnaround and success story in Philadelphia in terms of changes in practice that just took, leadership and focus and determination, and it's been a huge turnaround. So it can be done. If it can be done in Philadelphia, it can be done anywhere. And so it's been really positive. So anyhow. Okay, we're gonna try to wrap up this document and then move to more documents. We're on page 37, and this is the final part about that judicial proceeding. So we can, we'll accept any suggestions for what label we use instead of recommendations, whether it's benchmark or policy statement or whatever you want. But the idea is this section is not about conformity to the guidelines. It's just setting expectations, identifying some standards or whatever you want to call them for courts to consider and then to act on their own. And so we are trying to put in place a couple of things about general policies. The first one is about concurrent and consecutive sentences. We've talked about this before, about trying to identify cases where there's a starting point of concurrent sentences, and there's plenty of exceptions to the rule in terms of consecutive sentences. In addition to what we have listed as examples of consecutive sentences, we've added a few more that have been suggested during public hearings. So some of these include multiple convictions. Let's see, courts are here. Suggested to expand to include circumstances involving domestic violence, vulnerable victims, and sexual assaults as reasons for offense-related reasons for consecutive sentences. So we list right now sentences for crimes of violence, and the suggestion is expand that to include domestic violence, vulnerable victims, and sexual assaults. And when we move to the second page or the last page, we get down to the reason being proceedings in which there are multiple crime victims, sort of expand that or add a new category that takes into account separate criminal incidents, or perhaps, and this we just talked about, when a longer sentence is warranted to address treatment needs. So those are some suggestions we received in terms of exceptions for which consecutive sentences might make sense. So that's the takeaway from that part. And then the other thing just in this entire section that we're trying to be consistent about is to use the language or the term encouraging courts to consider. So these aren't recommendations, they're just like encouragement. Here's a policy framework or a statement or a benchmark or whatever else, and we're encouraging courts to consider this. And this gets to not only the consideration of correctional programs or county sentencing programs as alternatives to confinement or typical confinement, but also the idea of aggregate probation sentence. What should be the total duration of probation when you have a bunch of counts and you can decide whether to run them concurrently or consecutively. So instead of saying we're recommending this, we're encouraging courts to consider caps or these targets or whatever you want to call it. So I think that's the extent of the comments we received for the draft. Open to any final suggestions, comments, whatever from members, and then we're going to look at some of the OGS assignments.
And for the suggestion regarding circumstances when a longer sentence is warranted to address treatment, were there particular situations that were referenced in which the treatment was a longer sentence? I'm just curious about what
Yeah,
instances those were
I
referring
think
to.
it was as I understand it, but I'm I could try to find some examples from those that suggested it, but as I recall, it was linked particularly to the duration of probation and limits on that, and suggesting for certain types of offenders, and maybe especially, I'm not even going to talk about specific examples, except that I think there were suggestions that some treatment, takes time and is involved, and that there should be some latitude given to courts in terms of when they run sentences consecutively, so that they have adequate time to impose an appropriate treatment plan. That should be an exception, and that I think that conceptually makes sense. I'm not sure what the outer limits are. I'm not sure of specific types of treatment programs that require that. I will give like one example though to keep in mind. And if you think about the DUI statute, and you have a lot of repeat DUI offenders, what the statute provides right now is for someone who's drug dependent and is convicted of DUI, the statute provides that you impose the statutory max based on the grade of the offense, so that there is adequate time for treatment. So there's mandatory minimum sentences, but there's this provision of requiring the statutory max as well. And that's all about making sure there's adequate time for treatment. So this is not inconsistent with that kind of approach of making sure there's adequate time. Keep in mind, we have F2 DUIs now. So that's a 10-year statutory max for what might be a 1-year mandatory pen. Okay.
No other comments? Oh,
Yes.
one other comment.
Sorry, quick one. With regard to the concurrent and consecutive sentences.
Yeah.
And I just want to clarify so I know that the language has been, or it's proposed that it's changed where it's encouraged to consider the imposition.
Mhm.
Underneath that, when we look at exceptions include,
Mm-hmm.
okay, sentences for crimes of violence.
Mm-hmm.
With regard to are we let me see here, suggestions to expand include circumstances involving domestic violence, vulnerable victims, sexual assaults.
Mm-hmm.
Did we discuss that?
That's what I had mentioned. Yeah.
Okay.
That we'd expand sentences for crimes of violence to include those other examples as exceptions. So the policy is written about encouraging the consideration of concurrent sentences when you have basically lesser offenses within a criminal incident. And then the exceptions would include these things, and crimes of violence would be one, but we'd add DV, vulnerable victims, sexual assaults in that category.
And for vulnerable victims, who all's included in vulnerable victims?
Well, I think we wanted to keep the language broad. The suggestions that were raised were minors, elderly, intellectually, compromised individuals. So there were a lot of examples, but we were trying to, these are broad guidelines.
So that's
and we're
open
just
for
talking-
interpretation
Absolutely.
and will be based on the adversarial process.
It will. And remember, this is
Okay.
about the exception. So it's a pretty broad exception.
Sounds good.
Okay.
Thank you, Mark.
You're welcome. Anything else?
Move
All right.
on.
So here's the plan. We're going to quickly switch over to a number of just a list of offenses. I've highlighted ones where there were questions raised about OGS assignments, and let you decide if there's any changes you want. And then we're going to have Matt talk briefly about the resource utilization that we did so that you can know the impact of these changes. So the first document is the Crimes Code document. And you know, this is a huge document. So what we're going to do is just page through until we find highlighted sections, and I'll make a comment about them. If you want any changes, this will be your time to consider a change to the OGS. So as maybe just keep paging down, I think the first one is going to be, just keep paging. There you go. Okay. Okay. It's just Article B. So we're in Article B, which is where there was the focus about the seriousness. The first one there, and it's in green because it's just a question that was raised. I think in Pittsburgh, especially, we heard about drug delivery resulting in death. And the concern that the recommendation is actually relatively high. Now, it's consistent with the current OGS assignment, and it's consistent with the data that we saw. The median sentence fits this assignment. But what was discussed during the hearing was there are sort of like two categories of offenders that fall into drug delivery resulting in death. One is, a dealer that's selling fentanyl and someone dies and all that kind of stuff. But the other situation that might be equally common is when two people, two friends are together and someone provides some controlled substance and the person dies because of it. And so you probably do see a split in sentences in terms of those different fact patterns. And this one probably represents the case of a dealer and, someone who's receiving something and overdose and dies. And maybe it doesn't as much represent that, two friends getting together and one dying as a result of sharing drugs. So I think the recommendation or the discussion during the meeting in Pittsburgh was to sort of leave it the way it is, but certainly as a mitigating or departure factor, courts could consider these other circumstances depart below the guidelines. But I wanted to draw this to your attention in case there's any suggestions for either subcategorizing or changing the OGS assignment. This is for an OGS 22, which for a 0 prior record score is 60 to 72 months. So it's within the footprint of what our current recommendation is. And it is the omnibus score for felony 1, where the statutory max is greater than 20 years, which is the case for this offense.
Mark, I would
Yep.
suggest that we leave it the way it is.
Okay.
I know that a lot of the issues that were raised, and correct me if I'm wrong, are actually covered under nature and circumstances of the offense and history and character of the person. And that's why we created an exhaustive list of recommendations
Got it.
under those categories. Would you agree with that?
Yeah, that makes a lot of sense. And I think that's consistent with the discussion in Pittsburgh. That if there's a good way to subcategorize, we would, but it's probably best left to the discretion of the court. Okay, we'll keep moving down through. The next is sort of categorical, so we'll start right here, but know that this applies like across the board. For all of Article B, which are offenses against persons, the recommendation was that for F3 offenses, we consider increasing the OGS to state prison from county jail. So these assignments, and there's many, many, many more that are F3s under this article of the Crimes Code, are generally county assignments. And that's because that's what the data suggests. The median sentences, as I said this morning, are generally 3 to 6 months in these areas. And so they fit the right footprint, but the recommendation I think that we've heard was sort of a policy change that sort of as a default for these offenses involving personal victims, and especially when they're like second or subsequent offenses, things like that, these F3s be increased to an OGS 13, which would be the base of the state prison recommendation. And an OGS 13, just as an example, has a standard range for a zero prior record score of 12 to 18 months. So this would be categorically, or for many offenses in this category, moving them from county to state. So that's really a policy decision for the commission. The data does not support it in terms of what we see in sentences as far as the median sentence, but there are clearly sentences that do get state prison. They are just well above the median. So I'm going to ask Ryan just to sort of page down through. You'll see that there are many of these that fall into this category. And in the statement from a number of DAs, but also from the AG's office, they specifically talked in terms of the offenses of stalking, sexual extortion, a number of other offenses that are all included in this in B. And then they extended it to some other areas like other chapters of Title 18. So you can see there just a lot of various F3 offenses. And I'd say just until you get to the end of this or this.
And Mark, for these F3s that we're looking at right now, that are highlighted on the table.
Right.
So if someone has no prior record,
Right.
then what we're looking at, you said OGS, or I'm sorry, a guideline range of.
Right now, these are all county. I think all of these are county sentence recommendations. So if you see a 10 is a minimum term of 5 to 8 months, or an 11 is 7 to 10 months, something like that. So these are all county jail sentence recommendations. And what the recommendation was sort of categorically for these F3s was to move them up to state confinement of OGS 13, which would be 12 to 18 months. Much from a policy perspective, it made sense, but much higher than what we're seeing as typical sentence.
And I'm going to speak against it.
Okay.
I mean, even just a quick look at the grid, and you look at how many state sentences we have, how many county sentences, probation and restorative sanctions. So at first glance, it's like, whoa, we're really starting to cut down on, I think, the whole purpose, or a lot of, not the whole purpose, but the purpose of the redoing the guidelines, to take a look and see how they comport with reality. So that's the first thing. The next thing is the second half of that sentence, comporting with reality. This is based upon the data that we have. So what I am going to suggest, without sounding harsh, is maybe those people want it, but they haven't convinced judges, or they haven't offered it for individual cases for them to have so many concerns, because it would be reflected in the data, I think, that the judges respond. And lastly, and maybe we shouldn't use the word traditionalist in terms of sentencing, but it's individual. But my training background always is, you give a guy, I don't want to be sexist, or a woman with an F3 with no record, you don't send them upstate first time. That is, if it's a bad case, an F3 can be on the cusp of probation, or it's county jail time. I don't know, in my experience in communicating, not just in my county, but with other judges, that most judges start sending someone to the state with an F3 for the first violation. So I'd like it to stay the same.
Any positions in
And
contradiction?
let me just throw in one other, abbreviated view, and just from what we heard as comments, and that was, would there be support for selectively looking at F3s that deal with, say, second or subsequent offenses, to distinguish them more from the M1s that are first offenses? And the idea there was for offenses like stalking, where the M1 might be a 7, which is county jail, and looking at the F3 and increasing that from 9 up to 13. So there's a distinction between first offense, which is an M1, and second or subsequent, which is an F3. and having one is county jail, the other state prison. So it deals with second or subsequent rather than a first offense, but it's still an F3. The data still supports county jail sentence, but I just wanted to make sure I'm communicating what I heard in terms of concerns.
And my response to that is the state legislature has given us their guidance by making those enhanced crimes by elevating them to an F3, not to an F2 or not to something else. I mean, and I don't know. I mean, I'm trying to think what else it could be besides stalking, retail theft, and other ones. So my position, I can't think of many, but my position would remain the same.
Okay.
But other people may have difference.
Let's find out. Anybody have any difference of opinions who's seated here or on Zoom?
Well, one of the questions I have, just for more of a clarification, Mark, is as I'm looking through the crimes here that are highlighted, some have a current OGS of 9, some have a current OGS of 10.
Mm-hmm.
And again, maybe it's late in the day. How did that category get put together?
Yeah. So two ways. First, we ran data for 3 years of data to try to find that median sentence and try to look at what's the typical sentence for these offenses. And we tried to focus on cases where there were at least 25 cases. So that was like the starting point, 0 prior record score, 25 cases, and look at the midpoint sentence to figure out that. The other thing is we used the current guidelines as like a footprint because the guidelines are broader right now. And we said, whatever the new one is should fit into that. So if we have current guidelines that are both probation and jail, and then we looked at the data and the data was probation, we gave a probation OGS. And if it was jail, we gave it jail OGS. So we try to use the median to figure out where in the current range we'd put this. So these generally reflect a part of the current range. And I think the recommendation in some of these cases is that the current range included both county jail and state prison. And in these cases, we selected county jail because the median, and they might recommend state prison instead, even if it for a policy reason that we should distinguish them. The second thing that comes into place is just sort of this view of proportionality. So I'll give you an example, and Ryan, maybe you could turn to institutional sexual assault. So it's 3124.1. So here's institutional sexual assault, which is one of those areas where there's a request to increase these, or at least some of these, to state prison. So if you see the first one listed is that offense generally, the F3. And so the baseline assignment based on what I talked about is an OGS 9. And then what we did was we looked at when there were other factors present, whether elements or sentencing factors, and we would adjust the OGS to take that into account. So you can see those other factors like victim less than 18 or school volunteer or whatever was like a separate additional factor. And so we started with the 9 and we bumped it up 1 OGS to reflect the additional factor that was in place. So that's why you see OGS 9s for some of those, because those are like the baseline ones. And then OGS 10 reflects that there was a second factor that went into the OGS assignment. So that's just an example, but that applies across the board. And like I said, some of the feedback we received, and I know some of this was from DAs, was particularly for second or subsequent offenses, for certain violent offenses, sexual offenses, that's where I think they particularly were saying maybe the F3 should be treated differently than the M1 or differently than other F3s, and it should be state prison. The problem is you start getting to this sort of disproportionality where we have a lot of F3s and a lot of offenses that all sort of fit together, and then we're taking some of them out and increasing them because they're second or subsequent, but there might be other factors that could argue the other stuff would be pushed up. So then it gets to, let's look at the data and see what happens. And most of those, the sentences are typically county jail sentences. So as I said, this is as much a policy decision by the commission to say, We just are going to treat these differently. We're going to prescribe something instead of having the guidelines describe what's happening. So, so getting to Judge McDermott's point, you know, there's a good argument that the F3 assignment to county jail is based on all that we've done, the sort of the construct we have. But the commission can override it and say, instead, we go with state prison.
Now, the intent of the in the eighth edition, the proposed eighth edition sentencing guidelines, are there any, and again, like, I apologize if I've missed this, but are there any other categories, let's take murder 3 out of it, that can span from county to state sentence?
Oh, sure. That's
what I thought, right?
There's a lot of them, and from county jail to probation,
Right.
and sometimes all three: probation, county jail, state prison. And so, and you'll hear this when Matt talks about the impact. When you take a midpoint of all sentences, and let's say there's a whole bunch of probation, a whole bunch of jail, and you take a midpoint, you're sort of excluding the other cases, right? Because you're saying, oh, we're going to go with jail. But there's a bunch of probations that you're basically elevating the recommendation. Or if it's jail and prison and you say, let's go with, you know, jail, there could be a whole bunch of prison sentences, but they're less than half because the midpoint pointed to the jail decision we made and the whole thing fitting within the footprint. So anytime you reduce from 2 or 3 dispositions or options to 1, there's going to be, you know, cases excluded. And I think our point is that's where aggravation mitigation comes into play. That's a lot of other kind of issues. And that might sometimes be addressed through concurrent consecutive sentencing too. You know, we're talking about an individual offense here, but if this is a case where there's multiple counts, you might then end up with an aggregated prison sentence, even though that individual count is a county jail.
You know, it's interesting. It's sort of like the law of unintended consequences here. You know, I know, for example, in York, we do a tremendous amount of where we provide pretrial incentives. And that might be for a lot of these F3s, where someone has to do a lot of things on the accountability spectrum. And if they successfully complete
right,
a lot of those, whatever it might be, right?
Yeah.
Where, especially where we're looking at, you know, intensive pretrial supervision, treatment, you know, and obviously the data is overwhelming that if someone does successfully get through that, then the odds of them committing additional crimes goes down tremendously.
Right.
That being said, the data doesn't capture all of the cases where someone goes through pretrial, or they, you know, utilize pretrial incentives or something of that nature that ultimately results in a sentence that might be a little bit less
right
than what it would have been had they not gone through that whole process.
Yeah. But so 2 things to keep in mind. One of the reasons we kept the footprint of the current guidelines is to make sure that we don't go radically one direction or the other, because there was a concern when we saw big mitigation where there are a lot of sentences below the current standard range that we use the current range as sort of the safeguard to say things like that happen. And what we're going to do is use the bottom of the standard range, not the mitigated range. So we're not totally wedded to the median sentence. It's the median sentence as it fits into the current footprint. So it's to avoid big things like that.
I apologize, Mark, but I
Yeah.
want to make sure you understand why I'm saying this, because I would hate to see a scenario where through innovative processes
Right.
that incorporate copious amounts of accountability,
Right.
that we're sort of a victim of our own success.
Yeah.
In that the guidelines would keep going down.
Right. And that was the concern. And that's why we're staying within the current footprint.
Okay.
So we've not gone into the mitigated range for setting these, and we haven't gone into the aggravated range. We've stayed within the current standard range, and we've just figured out what part of the standard range applies. But to your point, and I think I appreciate that point, and I think it's a good point. One of the things is that part of what is a typical sentence then in York is this whole experience with a lot of people being diverted or having access to programs and things like that, which means that those that do get before the court for this, that haven't benefited or taken advantage of those programs, are exceptional cases and maybe argument for an aggravation, right? Because you had all this other stuff in place and it didn't apply in this case. So the case that's before the court is not typical. So I think that gets back to this general argument that, we have to encourage courts to look at cases individually within this framework. And I think what has happened over time is the standard range becomes this safe harbor. And sometimes there's this reluctance to go outside of it when there's factors exactly like what you said that are relevant and important to consider. So I understand your point about, we might be moving, progressively lower, but we do a pretty good job of incarcerating a lot of people in Pennsylvania. And so I think this reset in terms of trying to set guidelines around current practices with exceptions is to try to then start that conversation and try to get things on track, because in the past we've set really high guidelines because we know that that's the interest, and then we see really low sentences and there's a disconnect between the two, and we're trying to connect all of this.
Thank you.
Thanks. Okay, here we go. So the general question for the commission with all of these F3s, for Article B particularly, but there's some other areas, is just if there's any change. So that's the takeaway from that. I know Judge McDermott expressed
Leave it
she's
as is.
content as
Yeah.
is, and I think that makes
Is there anybody who's present here today who is not content with to leave it as is and wants to modify it? And if so, in what way?
okay. Well,
And
This
if
will
I
also
can
be
say,
before the
we can
commission
look
tomorrow.
at these all, but when you hear institutional sexual assault and you look at those, they like are a gut punch, right? So and I think that's what happens a lot when you said we used to be high, because that sounds right. But they aren't seen as frequently, these charges. And a lot of times these charges are in conjunction with other charges in real life. I mean, these generally aren't floating out there by themselves. So by and large, and probably the reason that they're falling where they are in the county is because of some negotiation. I know that's not exclusively, but a lot of things just give you that gut punch. Therefore, our reaction is therefore higher.
And I'm
But-
thinking, Judge, of a lot of domestic violence cases, especially with the stalking, where we know that, again, the data is overwhelming that a victim may not come forward. There's all kinds of issues there. And so ultimately, when that case does come forward, especially if it's a stalking, there are some, and obviously and I know, Mark, my guess is, having been on the commission as long as I have, that the response will be, well, these are guidelines, and that's why we have the ability to deviate therefrom. Am I right?
there you got it.
Okay.
Typical offense.
But I said it
Yeah.
pretty quick, though.
Yeah, you do. Sure. That's good.
Okay.
And I'm just turning to you because I know that there's a lot. And you also live in a world where you have so much diversion in your system. You see it in a different lens than, like, in my county, we don't have any of the programs you have. So we all see it from different lenses. But let's just consider it. And if you have some suggestions or specific offenses, let's bring that back tomorrow morning
Sure.
and we can revisit.
And here's another offense that was raised, sexual extortion, and just another example of, where it is and where at least some of those offenses, or all of them, the
So-
recommendation was.
And I appreciate that, Judge. So I will put a lot of thought into that. And if I identify any specific, any specific issues, I'll be prepared to argue accordingly.
All right.
So I
Yeah.
appreciate it.
I'll
Thank you.
limit
And
the
I
arguments to 5
appreciate it.
minutes.
Thank you.
No, and honestly, I made notes. I know some of the things that were brought up on the F3s in the public hearing: institutional sexual assault, corruption, course of conduct, indecent assault, F3s. Those were some of the other
Right.
areas that were.
Okay, so we're going to keep paging down through and see. These are all Article B. And then we're colored slide. Lots of offenses. So while we're paging through this, okay, here we go. We got something going on here. There we go. What was right there? But yeah, but those are, so these are sort of the same flavor. It was a different section of chapter of statute. This was intimidation of witnesses. So same argument was made. Just wanted to pause at that. Okay, going. And then here we go. There were suggestions from the defense side, and even I think this morning from the AG's office, that there may be certain offenses where we could consider reductions, especially for M3s. So the defenders were suggesting these might be examples of M3s that could reduce from 5 to 3, 5 to 2. So from a probation level to a restorative sanction level. They talk specifically about disorderly conduct and obstructing highways. But they also more generally said that, I mean, some, but not all, had recommended that all M3s should be OGS 2, so restorative sanctions. So I didn't sense a lot of support for a wholesale reduction from our previous discussions, but I just wanted to point these out as examples that were raised sort of in the other direction. And you might recall this morning, the executive deputy AG also mentioned fraud and a couple of other things that they have concurrent jurisdiction on might be areas where there could be reductions. Okay, and then these are just calling these to your attention. These were the sections that dealt with the child pornography, basically, and some of the assignments there. And these are, I believe these are all F2s, but this was the example that the deputy AG mentioned this morning. She said, what we've done is, if you look at the two highlighted ones at the top, those are two different age categories, 13 to less than 18 and 10 to less than 13. And then right below that is the less than 10. So this is what she was talking about. She said, through our enhancement, we increased the OGS value for that less than 10 to a 17. And then we created two categories for 10 to 13 and 13 to 18. The 10 to 13 is a 13, and the 13 to 18 is a 12. And so her argument or suggestion was we should just combine those two categories and go with the higher OGS assignment. And again, and we can do that, and that would be consistent with sort of our past practice. What happened was the General Assembly changed the threshold. The threshold was 13, and we had two categories based on less than 13 and greater than 13. And then they reduced it to 10. So we created this middle category. And the argument would be, let's just keep it simple, have less than 10 or prepubescent, and then 10 to less than 18 is the second category. And we have all of those at OGS 13.
And I'm assuming I know the answer to this, but I'll ask it. For the 13 to 18, if we bump that up to the 13, we'll still be in the footprint.
Yeah. We will. Yeah. And this was as much just, trying to build in our current guidelines, the space that we had. So yeah, I don't see if the commission's fine with it, I don't see a major issue in terms of combining those two into the category. It's pretty consistent with what we have. And it's sort of a consistent picture as you go through all of these. There's different OGS assignments, but it's it's the same theme about combining them. So no objection on that. We'll do that. I think that might be the last thing on this screen. Okay, so I'll show you just two examples in two other areas, and then Matt will really bring us to a close. So,
And then next meeting, Matt gets to go first.
yeah, that's true. So, yeah, B2 is fine. So this is Title 35, and again, we have some stuff highlighted. I don't think we're going to make any, well, at least based on previous discussions, I don't expect any changes here, but this is an issue that was raised by the AG's office, so I wanted to bring it before you. As you recall, with the drug felony provisions, and Matt did a lot of research on this as we were building the sentence recommendations. The idea was to really collapse the larger quantities of drugs, whether it's fentanyl or heroin or cocaine or, you name it. We have a bunch of separate categories, and we have very, very few offenses in those categories. And so what the commission agreed to do was sort of collapse all of these so that they have similar, they're basically in the same OGS category now. So if you look at all of the yellow highlighted, you'll see that they have effectively the same OGS, the base OGS of 16, and then we increase it to 17 because there's an enhancement factor, either distribution to minors or second or subsequent offense. And for all of the other categories, these are all, greater than 50 grams of whatever it is. So, the AG's office was saying, oh, we should sort of go back to what we did before, where we have higher penalties as you get to the bigger quantity. And the argument was there's so few offenses there. We should just keep it simple, have it with these assignments. And if there's, a huge amount of it, whatever it is, use that as an aggravating or departure factor, but let's keep this all simple. So unless there's an interest in revisiting this, I think the commission was pretty clear that we're going to stick with these all being combined. And we may streamline this when we do the final version of this to just package these all together so that anything greater than 50 grams would be with these assignments, not have these separate categories which mirror the current guidelines.
I just want to echo my agreement with that. And I think this is one of those cases where you may talk about the presenter's perception, because the Attorney General's office historically has only been involved in those larger quantity of substances when other jurisdictions ask for a sentence for assistance. So that perspective, I don't know if the word is skewed, but it's based upon limited exposure to what I consider the real world in all of our jurisdictions, the day-to-day that we get.
Right.
So
and
thank
they
you.
can
No,
argue,
I agree with that.
yeah, they can argue for an departure. So great. We'll keep with that. The final one is DUI, and it's going to be very quick. An issue was raised with DUI. A couple of issues raised. One was under the policy, we did not include prior DUIs if they increase we don't include prior DUIs because these new guidelines take into account everything that the DUI statute takes into account in terms of creating the statutory max and the mandatory minimum. An issue was raised during one public hearing about we do not make a distinction in the OGS assignment when there's a minor occupant or their second or subsequent or third or fourth. And the reason is that we built these new guidelines first around what the mandatory is. So the guidelines generally track the mandatory. And then we look over at the grade of the offense, and we have thresholds for each grade of the offense. And if the grade of the offense becomes higher than the mandatory, we switch over to that assignment. So we're taking into account two of the statutory provisions about DUI. What was suggested was we should also build into this an increase in the OGS when there's a minor occupant. And as you'll see, in some cases, there's 4 steps there. First time with a minor occupant, second, third, and fourth. The mandatory minimums take into account some kind of step up if there's a minor occupant. So I think, at least from staff's perspective, we think we've done everything we can with DUI in terms of having a standardized approach to OGS assignments. And we also recognize that what really drives DUI sentences are the mandatory. Our OGS assignment and guidelines are a pretty minor consideration when it comes to DUI sentence. So I cannot think of a sort of an easy and proportional way to incorporate minor occupant. There's too many moving parts. So if there's a recommendation about how to do that in a proportional way, in a uniform way, I think, it's worth considering, but I haven't found that solution yet. So at least my recommendation is we go with what we have and we can see by experience how things happen. But the DUI statute's pretty sophisticated, and I think it takes into account a lot of these factors already in the grading and the mandatory minimum. So
It's a good question. In this instance, minor is just anyone 18 below.
under 18 years of age,
18,
that's an
okay.
occupant in the car. And that's like, that's above and beyond all of the other provisions, the DUI statute about the BAC and the nature of the offending and first or subsequent and so forth. It's calculus. Pretty
Yeah,
complicated stuff.
And there's a pretty wide range of situations in that. I think
There is.
2 teenagers being knuckleheads versus someone with like a 3-year-old, those are 2 completely different
Yeah.
instances. Right?
And then in this, there's also, the issue of the DUI statute starts with ungraded misdemeanors at 6 months of probation up to felony 2 offenses with these extra enhancements on top. So there's a lot of stuff. I mean, I don't know how many pages we have just to capture all of these different instances, but it's got to be 8 or 10 pages like this with all the details. So it's, I'm just not sure we can improve on what. So with that, we are done with reviewing this. We can turn to Matt to talk a little bit about the resource utilization that he and a big team put together.
Dr. Kleiman, you're up.
Great, thank you. When we have a new proposed guidelines, it's our responsibility to prepare a resource impact statement, looking at the resources that would be needed to accommodate the changes. So as Mark said, these guidelines, the proposals are quite complicated, and we spent a long time trying to develop ways to create the prior record score specifically. We have a great understanding, of course, of the mapping of OGS categories. So Ryan, could you just scroll down to the list of the elements? So in preparing the guideline recommendations, it's a short series of steps, which is determining the offense gravity score. We know that our offenses each have 8th edition guideline OGS assignments. We're going to then take a look at any enhancements that exist. We can apply those also using the rules of the 8th edition proposals. We're going to then determine the prior record score and then consider the offense specific guideline recommendation. So Ryan, if you scroll down to the next table, please. At the up one. So to prepare this analysis, what we did was we looked at 2019 sentences that were imposed under the 7th edition guidelines. And we then utilized all these rules to look at where the placement of an individual was on the 8th edition guidelines to get a sense of what the sentencing recommendation is. I think a couple things to note that Mark has already somewhat highlighted earlier is we used non-DUI sentences. Since the DUI assignments are pretty much the mandatories, there's no difference between the additions. So we're looking at non-DUI sentences imposed in 2019. To develop so for the OGS and obviously the recommended sentences under the 7th edition, we utilize the PCS data to develop the prior record score. We worked with the Pennsylvania State Police to obtain rap sheets and create these rules for the prior record score. And I just want to highlight, and we've talked about this at many different commission meetings, maybe a 2 or 3 year effort that Brett was involved with to improve the way that PSP provides the commission data. And this was really our first usage of the new formatted data that's just used to be like a text file. Now it's actually in columns with data headers. So while the data is still complicated, figuring out the dates and the different rules, the delivery and the actual downloading and use of the data was dramatically improved. So that was we waited a long time for that, but we're really encouraged. So one of the considerations was when figuring out the resource needs for the 8th edition was what sentencing value, if you would, we would use for duration. As Mark noted, we have a lot of situations under the old guidelines, like as example, PRS 0, OGS 5, where the recommendation is restorative sanctions up to 9 months. That's the standard range recommendation. So when we see a median, and we're going to assign that to an OGS level as an example, we might have a median of 3 months and assign that to OGS 8. And what that's saying is we're providing a recommended disposition type to every person or individual who's in that cell. So as an example, way back when we started this process a few years ago, or in the middle of this, we looked at burglary offenses. So we were looking at not a home, no person in the home. And there were about 500 of those sentences in our 3-year period that we looked at for the median. The median sentence was 3 months for that particular offense. And 60% had a county sentence, confinement sentence. Roughly 30% had a probation sentence, 1% restorative sanctions, and 10% got a state confinement. In our model, because we're assigning it to OGS 8, PRS 0, everyone is getting a county confinement recommendation. It's our sentence that we're utilizing for this projection. So because of that, and then the other scenario that was discussed about situations where the median was below the footprint of the standard range, we would have raised that up to the standard range. So for those reasons, and without trying to make an assumption of what conformity will be like for these new guidelines, for this resource assessment examination, we use the lower limit of the standard range as the value that we're comparing when we look at the 8th edition. So if it was a 3 to 5 months is the standard range, we would use 3 months in that example of county confinement for that cell when an individual will be in that cell. So I know that's complicated, but the most important point is that we're comparing actual sentences imposed to the recommended sentences under the 8th edition guidelines for when duration is involved, using the lower limit of the standard range. So this table, and apologies if it's tiny, is really where the rubber hits the road for our analysis. So the first panel on the left side is months, and that is the 7th edition is the actual months received for individuals for actual sentences for state confinement, county confinement, and probation, compared to the recommended sentences using the lower limit of the standard range for the 8th edition guideline. So it's notable here that there's a deduction in the months or reduction for state confinement, county confinement, and probation. A lot of this is driven, if you remember, the reconstruction of the guidelines was to reduce the impact of prior record score, where we saw PRS in the past went up to 9 or 10 times the amount as you went across. Now we limited it to twice as much. So we see a reduction in months. The N in the middle is the number of individuals out of our sample. So we had about 67,500 individuals, and we could see how many received a sentence of state confinement, county confinement, and probation under the 7th edition guidelines, and then what the recommendations would be for the 8th edition. So we see a pretty significant reduction in state confinement, an increase in the number of individuals for county confinement, a reduction in probation, individuals receiving probation. And I should note, this is for the most serious offense in a criminal end, what this is based on. So it's not looking at aggregate sentences for consecutive. It's just looking at the most serious offense in a criminal instance. And then I think also notable, and if we think about what the 8th edition guidelines looks like in expanding the footprint for restorative sanctions and guidelines, we see a significant increase of recommendation for restorative sanctions under the 8th edition guidelines. The next columns are just the proportion of the disposition types. So for example, under the 7th edition, about 12.5% received a state confinement sentence. And under the 8th edition recommendation, slightly over 10%. The final set of columns, and this is important to understand county confinement, is the average months by disposition type for the sentence duration. So state confinement stays relatively really close, 31.8 months to 32.4 months of the average sentence. We see a large reduction in the average sentence length for county confinement. So if we were to think, and we looked at the end, that the number of people receiving county confinement goes up, how can we see the months go down in that first set of columns? It's because the duration of the the county confinement sentences are reduced. Probation is again, very close to the same duration length from the actual to the recommended. So in summary, we see a really significant reduction in the months from the recommended 8th edition sentences compared to actual sentences for state confinement, county confinement, and probation. And we see a large increase in the use of restorative sanctions as at least the recommendation. Again, we struggled or wrestled with for a long time of how to model or think about conformity to the guidelines. And we chose instead to just start with the lower limited standard range as our recommendation. Even though, like going back to that burglary example, in our example, when we look at the end, every one of those would have been assigned a recommendation of county confinement, even though in practice, 30% of the people receive probation. Because we have a firm recommendation now of disposition type when we expanded our own category. Okay, I'll move on and I'll be kind of brief about some of these other pieces. Keep going, Ryan. It's really pretty to the PRS one. I'm sorry, this one. Oh, sorry. So one of the things, you know, as we looked at those OGS assignments and we moved through them, is the idea that we were unpacking many of these categories. So if we had RS to 9 standard range recommendation, that's not a lot of guidance for judges about disposition type or even for duration. So scroll down a little bit. So if we were to focus on, tough to see, on the 7th edition is on the top, the 8th edition's on the side, and I'll just read these to you. We'll pick on OGS 5 again, which at PRS, prior record score 0 was that RS to 9 recommendation. We're now assigning 12.5% to OGS 9, 36.8% to OGS 8, and about half to OGS 7. And OGS 7 is a recommendation of 24 months probation. OGS 8 is 1 to 4 months county confinement. OGS 9 is 3 to 6 months county confinement. So we're having specific disposition types as well as specific durations that are a lot more narrow to give guidance, at least as a starting point for the judge when considering these different OGS categories. So really what this shows in bold is the unpacking on the 8th edition of one value on the 7th edition. So for many of these, they span across 3 or 4 OGS assignments, which also could cross over different disposition types, just like in that example that I just gave, that we had probation and have county confinement and different recommendations for county. So that spreads all the way up to our murder 3 categories, of course. All right, so scrolling back down.
Yeah, if I could just mention something about the, we heard from, one of the concerns that we heard raised was we created this new level PS2, and like no one's in there. Well, there are a lot of people. If you look at B2 and you look over to the far side, there are 9,258 cases that go into that OGS assignment. So we've created a pretty big chunk of cases that were those theft of less than $50 and those other kind of offenses, small amount of marijuana that went into that OGS2. The reason OGS1 and OGS3 aren't used is because there are adjustments in the guideline. And we want to make sure that courts can go down or up, like if there's an enhancement that you have a space to go up without getting into the probation category. And if you're at 2, we want to make sure there's space to go down. And it's a meaningful difference. So that's why we just targeted for level A. OGS2 is the assignment. And we wanted to make sure there were adequate number of cases. So, 6,000, 9,000 cases is a pretty big, chunk out of.
Okay, just one last point on this, because as I was pondering this, I looked at that exact cell and 65% of 92, I'm sorry, so 9,200, I'm thinking, how is it possible, we say earlier that 7,200 receive restorative sanctions on the resource implication? It's because as you move across OGS2, when we impose prior record score, higher prior record scores, it switches to the disposition type of probation. So a small proportion of these, about 1,400, the recommendation would be probation, even though it's OGS2. So obviously the sentencing recommendations based on OGS and PRS, it's just a static OGS. Okay, going down now to these bar charts, Ryan. Obviously, there's a lot of rules that go into how we calculate and determine prior record score. And we talked a lot, this is the first one, right there. So we talked a lot about different constructs and moving from 8 categories to this reduced set of categories, different rules about juvenile counts, when they're involved, lapsing, all these elements that define our new prior record score. So one of the goals here was to establish, of course, true zero. One of the ideas, currently prior record score 0 will allow some misdemeanor for you prior record score 1. So that top left is showing for people who had a PRS 0 in the 7th edition guideline, how would they look on the prior record score? And so about 85% are going to be in our new prior record score 0 category, and about 15% in prior record score 1. And I just want to note this also, which is not in this chart, but overall, under the 7th edition guidelines, a little over 42% had a PRS of 0, which again is not a true 0, and 37% under the 8th edition guidelines would be PRS 0. So this is only looking at PRS 0, but when we look at the entire sample, it's a small proportion that are now moving out of our 0 that were not our true zeros. If that makes sense. All right, Ryan, if you could scroll down to the last 2 bar charts. And so there's a lot of detail about how these map to the different levels. I'll just focus on the last 2. And some of this has some old labeling, so I correct that just in the way I speak about it. We'll start on the far right one. Of the people who had REVOC under the 7th edition guideline, 100% of those people would fall into 4, calling PRS 4 REVOC, but they remain the same. So, and then the cell to the left actually has a little typo that it should just be PRS for RFL under the 7th edition. How did those fall? And we could see that 71% are in PRS 3 and 20+% are in PRS 4. So there's a huge correlation here, of course, in how these map across. Some of these variations, the small cells or small heights could be because of the changes in definitions for juveniles. Some could be because of the lapsing policies. So, but when you look at the modal categories of heights, like 70, 93% are going to be in PRS 3 and 4. We're being pretty consistent at least with classification as you grow higher based on a really different decision-making rule is about the grade of the offense and how many of them there are, as opposed to this point-based system that we had in the past. With, of course, when you make the intersection of this and OGS, as I mentioned earlier, with a pretty dramatic reduction in the recommendation about on the. So I have one last final thing, and my apologies if I was talking fast. Maybe the coffee finally kicked in here for me. But we had and Mark already addressed this, but I just want to say this. We had some comments during the public hearings about racial impact or gender impact. And that's certainly something we will put together in the coming days or weeks and present that or share that with commission members. I think that's a really important consideration for us and something that we are in position now to share. As I mentioned, we were wrestling a lot with that conformity. This document maybe came out a few days ago because we were just finalizing how we were going to approach a lot of this. And it was pretty complicated, but now that we have our rules established, we can generate that. And I think it's really important, especially since what Mark said earlier, that we convened this academic review panel a couple of years ago, met with them 10, 11, or 12 times, talking specifically about these types of issues, about the impact of racial disparities, how we could think about reducing that possibly through the prior record. So more to come on that. But I welcome any question, comment.
Questions or comments? I just.
All right, let me just add one quick plug that I do want to thank our colleague Brett Miller and Jordan Zvonkovich and many others at the commission for. It's a pretty simple looking document, but weeks and weeks and weeks of work on this. So thank you.
And just statistically, it's having been a part of a fair amount of this process. Sometimes it's so much information, but when we hear it over and over, it just all, I can see it all coming together. You know, sometimes when we're in the midst of it, especially the more complex stuff, for me, it took a while, and I see it all overlaying. And I know if you're newer, some of it might seem a little overwhelming. And I'm happy to, in my layperson in terms of the statistics, talk to you about the processes and some of the things. And the academic review panel, I think, was originally when the individuals were solicited and agreed to do that. I think it was going to be for 3 meetings.
Very short period of time.
Yeah, but there was such an investment and such a give and take, and everybody was so enthusiastic that this grew into something really big. And so that's for those of you who don't know the history. Nice to know. I know everybody wants to stay here some more. Is there anything additional?
2 more. Yeah. 2 more
Okay,
comments.
that's-
So first I want to thank Matt and Brett and Jordan for all of their work and many others that contributed. It was a ton of work and about 20 different drafts that we went through, but I think it captured what we were hoping to capture. So thank you very much for that. The final thing that we need to address are the recommitment ranges, and it's just a small change, but we asked for comments on 3 proposals. So sentencing guidelines, I think we're done discussing that. Recommitment ranges, resentencing guidelines. We received no actionable recommendations about that, and we didn't expect any because it was pretty much what we have. So that moves forward as is. And then the final thing is are these parole recommitment ranges. And we worked with the board, for years on trying to develop this and trying to take into account their activities, but also, and I think what the reason for some of these changes were trying to capture sort of the reality of what they're dealing with. Like, how much time does it take to process someone through a community correction center, or when is a person available for programming, or if someone denies the allegation of a violation, how does that set back issues? So there's those like practical factors that we have to build into the consideration of this. But in the end, what I'm really happy about was the effort, the recommendations that we created around convicted parole violators, where we linked them to our new guidelines, the new sentencing guidelines, like held up, and no comments against that. A lot of people thought that was a good way of communicating between sentencing and parole, the activity. So we think that's a really positive thing. On the technical parole violators and the recommitment ranges, here's a couple of things that were suggested, and I think they're really helpful recommendations. So I thank the board for this. The statute requires that we have different guidelines for non-violent versus violent individuals, and the indicators we used for determining that are the same ones we use in the parole guidelines. So there's consistency there. And then regarding recommitment, in statute, there are standards for how much back time someone can receive for technical violations. And it's based on whether it's first, second, or third or subsequent violation. And there's a difference between committing someone to a correctional facility, like a jail or prison, contracted jail or prison, versus to a community correction center, community correction facility, or a parole violator center, which are sort of non-correctional facilities, if we want to use that term. So the recommendation we had for a first violation for a non-violent offender was a maximum of 6 months. And effectively, we were saying it should be like 0 to 6, but people aren't going to be recommitted if it's 0. So we didn't want to put 1 day. So we just said a 6-month max, like no more than 6 months should they be sent back for a first technical violation. And what the board said was it might be more helpful to describe that as time served to 6 months, because we don't know how long they're going to be there before they're going to be eligible or complete the programming or whatever. So I think that's just a valid concern. So if you look there, we just added time served and got rid of maximum for 6, 9, and 12 month, or first, second, and third and subsequent. And then we applied the same to the recommitment to a CCC or CCF. Over on the violent individuals and recommitment ranges, the only difference there was for the recommitment to a CCC, we had a 6-month maximum. And just due to the logistics, that just really didn't make much sense. It would be very difficult for the board to act on a case that was that there was a recommit for less than 3 months. So we decided to just put in a 3 to 6 month range for that and get rid of the max. So those were the only like very technical changes, and they're driven as much by just how these things function with the board. I just want to commend the board for them being very helpful throughout the process. It's been probably 10 years or more that we've worked on this kind of stuff. And I think this is going to have a really good impact. And as I said, especially for the convicted parole violators, I think the biggest takeaway from this is at the time when a person is convicted of a new offense and the judge is sentencing the person on the new offense, the judge will have an idea of what type of back time or recommitment range the board is going to be considering. And when the board is considering a convicted parole violator, they will have a sense under the sentencing guidelines what the judge will be considering for sentencing that person. And that has not been the case until these go into effect. So having everyone working on the same page will help, because there's no one way or one order in which a new sentence and a recommitment decision are made, because there's a lot of factors that determine who goes first and how it happens. So having each have information about what the other will be viewing is, I think, incredibly helpful. And so this is, talk about transparency or coordination or whatever the right word is for this. This is that. So, so with that, I think we are done. Dinner tonight is at 6 o'clock at the Hilton. And I think that's all we have.
Anything else before we adjourn? All right, we're adjourning.
Thank you all
so much
for a
to
very long
to everybody, really.